registration, no rear mirror, trafficking and controlled substance, first degree, second offense, possession of drug. Mr. Cross, you acknowledge the identity of your client, received indictment, waive formal reading and arraignment, and plea not guilty, reserving all pretrial motion.
Yes, Your Honor.
Yes, sir, I'm signing a reciprocal discovery order here that requires the Commonwealth to give your attorney certain information to help you prepare for your defense. You need to be here on January 29th at 9 a.m. for negotiations, and February 8th, your next court appearance.
Okay.
Been no complaints that I'm aware of, so you're under the same bond. Okay?
Yes, sir. Thank you.
Okay.
Thank you.
Jesse Phillips, active warrant. Mr. Stockton.
Yeah, we'll look in and see how I see you.
Terry Phillips Jr. for review. Are you Terry Phillips Jr.?
Yes.
What is this, Mr. Stockton? What kind of review?
This is a review to see if he's paying restitution. He's paying restitution. It's court's order.
Okay. When do you want him to come back?
I don't think I will need him back other than just, for the problem. And then if it's not paid off, if the civil case is not resolved toward the end of the diversion, we'll have to do something.
So we continue as generally subject, you redocument with notice to the attorney.
He still owes about $261,000 on 2009.
Yeah, so there's 50,000 got paid for
But that's going to
that.
have to be corrected some way. I've not got anything.
Yeah, I understand.
Okay. So what we need to do on this is you need to keep in contact with your attorney. So Mr. Stockton give notice to the attorney if it gets redocketed, okay? Okay, thank you very much. William Shickles. Commonwealth versus William Shickles, 23 CR 0052. Are you William Shickles?
Yes, sir.
You born in 1979?
Yes, sir.
Last four digits, your social security number 9169.
Yes, sir.
Here for a pretrial conference. What do we have?
We'll have a plea, Your Honor.
Mr. Stockton, will you come in?
Pass it a little bit. He's in Edgewater recovery. Won't have a plea if you pass it so we can do the paperwork.
Today?
Yes,
Okay.
Yes, Your Honor.
Okay, we'll call you back up here. Alfred Silva.
Judge, he is on his way. He is staying in Somerset and I had to schedule transportation through RTEC for him to get here. And they had a little mix up this morning, but he's on a bus and he is en route. He will be here in just a few minutes.
Might be like New York City. We'll find the bus and contempt. Sue him. Cody Smith. Cody Smith.
Maybe outside, Your Honor, it seems in court, he always attends court. So,
Commonwealth versus Cody Smith. 23 CR 0067. Are you Cody Smith?
Yes, sir.
You born in 1992?
Yes, sir.
Last four digits of your social security number 4867.
No, sir.
What are the last four digits?
4267.
4267. Please make note of that discrepancy on. Mhm. Yeah. Mr. Stockton, the wrong social security number
Okay.
is on the indictment.
What is the correct one? And I'll go ahead and say, Mr. Whittenberg, furnish me out in order correct.
Okay, I won't say it out loud, but why don't y'all just change it because we were broadcast. Why don't you just change it and then I'll initial it, okay? On each one. See if they're just line through it, put the correct social security number instead of.
it's right there.
He doesn't have to initial it, I'll initial it. Thank you for the initials, so. I'll just line through, the rest of them. You have the right to remain silent. You're represented by counsel Cody Smith, as you previously identified. The grand jury of Clinton County has returned an indictment charging you with assault in the 4th degree, wanton endangerment in the 1st degree, terroristic threatening in the 3rd degree, and intimidating a participant in the legal process. You acknowledge the identity of your client, counselor, receive the indictment, waive formal reading and arraignment, enter a plea to not guilty, reserving all pretrial motions.
I do, Your Honor.
Okay, I'm signing a reciprocal discovery order here. It requires that the Commonwealth to give your attorney the information to help you prepare for your defense. What's the story on this, Mr. Stockton?
Well, the only issue I'm aware of at this point in time is regardless of bond.
Y'all move to the left here, get behind.
I've been in contact with the victim. The victim, Mr. Smith, have children together. And he's wanting to contact the children, but due to the nature of the charges, he doesn't need to have any contact with her. That's what he was said, that I have an audio recording.
Is there EPO or DVO in
There is, Your Honor.
the district court?
We've got.
Were they ever married to each other?
No, Your Honor. We've got a pending motion from Judge Lawson for the DGI. I think he came in yesterday's office to see about getting restrictions removed as far as for him seeing the kids and I guess get a no contact towards her so they can communicate back and forth about the kids. Your Honor. And then we'll have I guess motion about custody on the kids as far as that goes.
That's the problem. I don't think he should be having contact with other, you know, I think the district court of ever should handle visitation, but I don't think that in this case, I don't want the kids to be a vessel to be used to talk about it. That's the problem I've got in this case, because this is pretty graphic.
Well, it's very difficult, you know, when you have these two courts handling something like this. So right now I'm going to be put at the request of Commonwealth, have a condition on, getting a condition on bond. He had no contact with the mother of the children. And, I think that order will hold. This condition is bond. If he wants to have contact with her, then he'll be in jail and he can try to use the jail phone.
Your Honor, the way they had it
You
worked
understand
out,
what I'm saying?
the way they had it worked out at the district court, my understanding was either your kids called you or you called them directly.
Well,
They had
let's
their
see,
own
that's
phone.
not, that's neither here nor there. I'll let the district court determine how the contacts with the children, with the caveat that he can't be involved in calling the mother. They can work that out down there.
But if that continues, that wouldn't be a violation of circuit
If he
court.
doesn't talk to her and he's not in contact with her, I don't care what they do in the district court. That's Judge Lawson. I trust his judgment on that thing. You agree with that? You know, I personally, until this is sorted out, wouldn't give him any visitation or contact with the children. If I was doing the EPO or DVO until I had a hearing on it. Have y'all had a hearing on it?
There's already been a DVO established, John.
Yeah. Okay. That's my ruling. He'll be back here on January the 29th at 9 a.m. for negotiations, and February the 8th for his next court appearance. Both of those are conditions of his bond.
Your Honor, if we have the 8th date changed, I've got a trial in Wayne County starting
That's my
Thursday.
rule date. I can't change my rule date.
Okay. I'll see about having somebody come down and cover.
Yeah,
it.
well, if you negotiate a plea or something, they can enter it that day. If not, you can bring somebody with your calendar down.
I'll do that.
Okay.
Thank you, Your Honor. I have nothing further in front of the court. May be excused.
Absolutely. Thank you. You know, Johnny Stevens. So I'm sitting, let's go. Johnny Stevens, Commonwealth versus Johnny Stevens. Commonwealth versus Johnny Stevens, 18 CR 0059. Sir, are you Johnny Stevens?
Yes, sir.
You were born in 1977.
Yes, sir.
What are the last four digits of your social security number?
39, 40,
39 what?
40, 40.
You're here today for review. What does the Commonwealth have to say about this?
Your Honor, it looks like Mr. Stevens has this paid down to either 1166 or 1066. He just recently made $100 payment. So I'd ask for a review in 60 days, so make sure he keeps paying.
Be back here, stay in contact with your attorney. Be back here March the 7th unless you're cleared not to come, okay? About making payments. Thank you.
Thank you.
Kyle Thomas. Okay, moving down to, he's in Clinton County. John Tucker. John Tucker. Commonwealth versus John Tucker, 23 CR 0054. Are you John Tucker?
Yes, sir.
Born in 1984.
Yes, sir.
Last four digits of social security number 2409.
Yes, sir.
You're here today for the purpose of arraignment. You're represented by counsel, Mr. Cross. You have a right to remain silent. If you have any questions about the proceedings, step away from the microphone and privately communicate with Mr. Cross, okay? The grand jury of Clinton County returned an indictment charging you with unlawful use of electronic means originating or received within the Commonwealth to induce a mind to engage in sexual or other prohibited activities. Prohibition of multiple convictions arising from a single course of conduct, solicitation as evidence of intent. You understand those charges?
Yes, sir.
Yes, Mr. Cross, you acknowledge the identity of your client received indictment was formal reading or argument pleading not guilty deserving all pre-trial motions.
Yes, Your Honor.
You sign a reciprocal discovery order that requires the Commonwealth to provide your attorney with the evidence that they have concerning your case. You need to be here on January 29th at 9 a.m. for negotiations, and your next court date's on February.
Your Honor, I
The eighth.
would anticipate that this prep on this will take a little bit longer due to electronic review necessary and such. I don't think it's going to be very productive to have it on the 29th of the 8th.
What do you have to say, Mr. Stockton? Come around here.
The discovery is not that extensive. If Mr. Cross is gonna hire an expert or something, it's not that extensive or something.
And see, I don't know with my.
Yeah.
Well, y'all just be there on that date, and if that's the case, you can give your reasons why you don't want to negotiate. And, you know, and your rationale as to how long you think it'll take to do that. I just like to keep it on schedule.
Fine, Ron.
Okay. Candace Tweedy. Commonwealth versus Alfred Silva.
She just now came in and I needed to get an affidavit on her for an attorney.
She qualified.
She will.
Yeah. Where, has she been processed yet?
She's been sir.
What happened to Alfred Silva?
He's here, He's here too.
Commonwealth versus Candace Tweedy, 23 CR 0058. Ms. Tweedy, were you born in 1997?
Yeah.
Last four digits of social security number 2464. Okay, the grand jury of Clinton County has returned an indictment against you. You're represented by counsel here. I want, if you have any questions about anything I say, step away from the podium and speak quietly to the attorney. The grand jury is charging you with possession of marijuana, possession of controlled substance, the first degree, possession of controlled substance, the first degree, no charge, and possession of great paraphernalia. You understand those charges?
Yeah.
Also, you acknowledge the event of your client receiving indictment, away formal reading, arraignment, interpleading not guilty, reserving all pretrial motion.
Yes, Your Honor.
Signing a reciprocal discovery order. You're to be here, ma'am, next time on January 29th, 9 a.m. for negotiation, and next court dates February the 8th at 9 a.m. and both of those are conditions of your bond.
She have any restrictions on her bond, with regards to curfew?
Yes,
I've been getting complaints from the city police about her being out midnight, as far as individuals and things. And I just want
okay.
to stop that.
Don't respond to that, okay?
Same thing.
I'm telling you, work, church, or the doctor. That's when you need to stay at home. And as they used to say in Monroe County, you don't need to be out of garment around.
Yes, sir.
Okay, thank you.
Yes, Your Honor.
Thank you.
Let's go back to Alfred Silver. Commonwealth versus Alfred Silva. 23 CR 0048. You're Alfred Silva,
Yes, sir.
born in 1962.
Yes, sir.
Last four digits, social security number 3706. Here for review today.
He's here for his duty to register. We missed that last court date. He needs to read it to him and he needs to sign all 4 copies and open the court.
Okay, why don't you take those in the back room? And you want to be there with him and go over it quickly, or?
Yes, Your Honor.
Okay, is there anybody else here on the live docket that was out? I guess we didn't do anything about Ashley McCusker, right?
Yeah, we're going to do the plea paper here.
Dylan Murphy. What about Dylan Murphy processing?
Be a solid.
William Schickles?
Twelve months for 2 years.
Working on paperwork for him. Alfred Silver just went back. Kyle Thomas is in the clinic. Okay, well, let's go off the record just for a second.
Anger management.
Okay, we're back on the record. Mr. Silva, did you look at those duty to register
Yes.
forms? Are they all in order? Did you,
Yes,
you'll
sir.
sign them now here in open court?
Yes, sir.
probation, or any other need to talk to Mr. Silver today?
I will after you sign them, they give them back, I will.
Yeah.
It's gonna make sense.
Well, in continuation of a very unusual day, my pen turned out, I'm gonna get an official pen, I can't be using your pen. Yeah. That's the worst thing that happens to me all day, my boy, this is. It's already not worse than it's.
And Your Honor, if I may, you had indicated to Mr. Silva, whenever we were here for final sentencing, if he could show proof of being admitted to long-term rehabilitation, that you would waive full costs. He is currently enrolled in long-term rehabilitation.
I don't remember that. Submit me an order.
Yes, Judge.
Okay, I don't guess we have anyone else here right now.
Thank you, Judge.
Yeah.
Thank you, Your Honor.
Yeah.
Mr. Sylvia, just wait right there and I'll be out.
Mr. Stockton back there. I'm Mark Food. Commonwealth versus Dylan Murphy.
She's got a young lady that's also had a young, I don't think she's gonna die. I don't know who she is.
Get them to the handful. Commonwealth versus Dylan Murphy. 23 CR 0057. Are you Dylan Murphy?
Yes, sir.
Born in 1996.
Yes.
Last four digits, social security number 1303.
Yeah.
You're here today for the purpose of arraignment. You have the right to remain silent. If you have any questions, step away from the podium and ask your attorney quiet. The grand jury of Clinton County has returned an indictment charging you with wanton endangerment in the first degree, 2 counts, and criminal abuse in the second degree, 2 counts. You understand those charges? You have to
Yes,
say
sir.
so audibly. You understand those charges?
Yes, sir.
Counselor, do you acknowledge the identity of your client received the indictment away from or reading arraignment and you're pleading not guilty, reserving all pretrial motions?
Yes, Your Honor, and just for the record, I will note, and I've already contacted DPA office above my head. Mr. Murphy is a co-defendant with Ms. Farrell. I have already had extensive conversations with Ms. Farrell, so no,
You
Mr.
handle
Murphy.
the arraignment though.
Absolutely, Judge. I just want,
What you're telling me is that you're gonna have to get conflict counsel,
yes, Your Honor.
okay? We'll have conflict counsel here on January 29th and at 9 a.m. and this gentleman will be there on the same date. And then on February 8th is court appearance,
Yes, Your Honor.
okay?
January 28th is 29th.
January 29th.
29.
29th. Change that and then February the 8th. Both of them at 9 a.m. Both of them motions of bond. Who else is here about it?
Who's next, okay? Earl.
Commonwealth versus Ricky Farrell, 23 CR 0056. Are you Ricky Farrell?
Yes, sir.
You born in 2004.
Yes.
Last four digits, social security number 2624.
Yes, sir.
You're here today for the purpose of arraignment. You have a right to remain silent. You're represented by an attorney. If you have anything, don't understand something, step away from the podium
Okay.
and ask him quietly. The grand jury of Clinton County has returned an indictment charging wanton endangerment, first degree, 2 counts, and criminal abuse in second degree, 2 counts. You understand those charges? Okay. You have to speak up.
Yes, sir.
Okay. Counselor, you acknowledge the identity of your client received indictment. Wait for reading and arraignment, enter plea not guilty, and reserving all pretrial motions.
Yes, Your Honor.
You'll be back here on January 29th at 9 a.m. for negotiations, February the 8th for your next court appearance. I'm signing a reciprocal discovery order. It requires the Commonwealth to give the evidence they have in the case to your attorney, so to help you prepare for the case. Both of these things are conditioned to your bond, okay?
Yes, Your
Thank
Honor.
you.
What is her bond?
10,000 cash.
Okay.
It was 50,000 district where she was on some cash. Yeah.
10,000 cash is sufficient,
Thank you.
and with the same conditions, okay? Okay, we have anybody else ready here? Who is this gentleman?
What's your name, sir?
Kyle Thomas.
Kyle Thomas.
Kyle Thomas, yes, Your Honor.
Commonwealth Kentucky versus Kyle Thomas, 23 CR 0051. Mr. Thomas, were you born in 1996?
Yes, sir.
Last four digits, social security number 4517.
Yes, Your Honor.
The DPA represents you in district court. He's what?
I had an arraignment, they had an arraignment for me, but I was in Wisconsin. I wasn't here for it, Your Honor. I knew nothing about it.
Is there a warrant out for him? What's he in jails?
Yeah, I think you're in December, that he ended service to the service for the title to December the 11th.
Good.
And also said to say his name, maybe not ready to back. And either the wrong stuff at back. You better come out, how be.
It's Alan Kyle Thomas. I just go by Kyle because my dad's name is Alan.
For arraignment.
That was the
Yeah, it's listed as pretty.
pre-trial.
Okay. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with wanton endangerment in the first degree. You understand those charges? Now, I'm not asking you what you did or not. You understand what the charge is?
Yes, Your Honor.
Okay, I'm signing a reciprocal discovery order in this case. The Commonwealth give you the evidence ahead. What's the bond in this case?
I don't have to involve you. I think it's for the record that, and I don't think it was a court case.
Mr. Stockton, have you looked at the allegations on face of violence, use of a weapon, and shooting in the direction of somebody, 5,000 sufficient?
Yeah, I think in this case it probably is because he was in an altercation with Joe Daly, who's a fugitive from justice, and I don't know if he's ever been picked up or not. And the reason I was alerted to this was my neighbor called me because he observed the altercation, which was I guess 1,500 feet of my house. And they were fighting in the road, and then Sheriff Markham got to investigating it, and then he brought the indictment.
Okay, I'll let the bond what it is. You're not to have any firearms about you though. You understand that? You understand that? You're not to have any firearms on you. You understand that?
Yes,
Not
sir.
in- not in the vehicle you're in, not in the house you're in, not anywhere. You understand that?
Yes, sir.
Okay. Okay, you be back here on January the 29th at 9 a.m. for negotiation. And February the 8th is your next court date. Now, you said you were where previously? You're at Wisconsin or
Yes,
something?
sir. That's where I was working.
What kind of work do you do?
I do roofing, industrial buildings.
Yeah, are you got out-of-state jobs coming up?
I do, but
Well, here's what Mr. Stockton,
Yes.
if he's working out of state as a roofer or something like that, you won't have any objection if he gives notice to pre-trial where he's gonna be located doing the roofing for him to continue to work with you.
No, I'll have no objection.
You understand what I'm saying? But you need to be specific in calling and have your attorney tell the Commonwealth Attorney's Office.
If he can make his ball,
If he can make the bond.
and
What is the bond?
5,000 cash, he got the ball, he has a criminal history.
Yeah.
I can't make the bond here.
Judge, could I ask for a surety or electronic monitoring in lieu of a cash bond so he can get back to working?
I mean, some of my family do, but I don't know if they're willing to. Okay. Yeah, speak.
You just step away and talk to your attorney. Today's been kind of like one paint dry.
And Judge, I think it's important to know Mr. Thomas is claiming self-defense in this.
Well, I understand that, or we wouldn't be talking. Mr. Stockton alluded to that. You know. But let me tell you what, when you've got nobody at all in your family or anybody else that'll sign even, I'll change it to $10,000 surety bond for somebody in your family come in and just sign a surety bond.
Thank you, Judge.
Thank you. Who else do we have here on this out of custody docket? Is there- Yeah, have you got paperwork being done on someone?
Oh, good. You can't. Motion every people that come on something and check.
Mr. Pennington, do you have paperwork you're doing on anybody?
Split up.
Judge, I think for waiting for Mr. Secretary right now, he's completing his PSI paperwork, so not.
You got the paperwork, you can go ahead and do it.
Well, I don't think that, he's doing the PSI.
Yeah.
The other charge is better.
No, I was just doing the misdemeanor. You take out the say. Okay, I didn't write it down. That's my fault.
That's okay. I'm glad we're looking.
That's the reason we don't like doing these in court.
Yeah.
Adair County, Adair County, if you'll join us, I see you're online. Turn your camera on. You need to turn your microphone on in Adair County. You are muted. There you are, Adair County. A case of Dennis Kempton, Commonwealth, Kentucky versus Dennis Kempton. Okay, you're off again, Adair County. Adair County. Okay, there you are, Adair County. Unmute your microphone. There ought to be a place on the screen there that's got a little microphone with a X across it. There you go. Can you hear me now? Hello? Hello?
We better use it.
Well, Kentucky versus Dennis Kempton.
Oh, the volume won't come up. I can't get the volume.
Are you Dennis Kempton?
I think that's the staff. That's a Class D facility, right? They don't do as much Zoom as the.
Most of them aren't from here. I've been there for several Christmases. Okay, moving right along here. The local basketball game doesn't start till 6. It appears we might be finished by then. And Adair County, if you have an 18-year-old house up there, they might be able to, usually younger people can get online better. Yeah. I remember when we first started using, here we are.
I don't know if y'all can hear me, but I can't get no sound.
Can you hear me now? Are the headphones plugged in? Maybe take the headphones out and the speaker will work.
Okay, I got it. I'm sorry about that, Mr. Williams, but we got volume now.
Can you hear me now?
Yes, sir.
Okay, you have Dennis Kempton there.
Yes, sir.
Okay. Commonwealth versus Dennis Kempton. Are you Dennis Kempton?
Yes, Your Honor.
You were born in 1974.
Yes, Your Honor.
Last 4 digits of social security number 8161.
Yes, Your Honor.
Your attorney is here, President Wade, counselor. Hello. Okay, you're going to be arraigned here on a charge. You have a right to remain silent. If you have any questions about what's happening here today, he'll be back in contact with you, okay?
Okay.
The grand jury of Clinton County has returned an indictment, Mr. Kempton, charging you with burglary in the third degree, criminal trespass in the third degree, and theft, unlawful taking, or disposition. I'm presenting this indictment to your attorney. Counselor, you acknowledge the identity of your client, receive the indictment, waive formal weekend arraignment, enter plea of not guilty.
Yes, Your Honor.
I'm signing a reciprocal discovery order here. Your attorney will be receiving certain information from the Commonwealth to help you prepare for your defense. He'll be up to see you right soon. You're going to be back here in court on January the 29th. For back here at the courthouse in Clinton County on January 29th for negotiations, and on February the 8th for your next court appearance. Now, is this gentleman being held on other charges?
He's a state inmate.
It's a state inmate, so he'll be up there to see you, okay?
Okay. Thank you, Your Honor.
There's nothing else there at the detention center, so Adair County, y'all are excused. Thank you for your help.
Thank you, y'all.
Is Kenton County on there yet?
Yeah, court.
Kenton County. What, Wayne County? Wayne County, okay. Commonwealth versus Jesse Pittman. Hello? No, somebody needs to activate the microphone in Wayne County.
Hello?
Okay, that's got it there.
All right, thank you.
Commonwealth versus Jesse Pittman, 18 CR 0074. Are you Jesse Pittman?
Yes, sir.
1986.
Yes, sir.
Last four digits of social security number 5676.
Yes, sir.
You're here today on what says to be a motion to vacate. Mr. Stockton, what do you have?
This is the case we heard last month where he was asking to vacate the 18 case because that's what he's serving his parole on. He was revoked on a domestic violence case, which I ended up dismissing, but the parole board had already given him a year to serve. I believe, is that right?
I think it was a six, yeah.
Yes.
And he's asking to go back and vacate the 18 case where he was involved in self-defense.
And Judge, we're,
DPA post convictions involved.
that's what I was about to say.
Is it Andrea Reed?
Yes, Your Honor. Samantha Costello reached out to me earlier this week and asked if post-conviction could take a look at the motions that Mr. Pittman has filed. We only have the one that was filed on November 8th of last year,
You need to
so.
move closer to the microphone and speak up a little bit. My sound system here is not great.
Okay, I'm not sure what you caught of that, but Ms. Costello reached out to me earlier this week to ask post-conviction to take a look at what Mr. Pittman had filed because it's a post-conviction action. And we only have the copy of the motion that he filed on November 8th of last year. We don't have anything else that he has filed yet. We know that you appointed somebody, I think at the local office, but there hasn't been an appointment order for post-conviction to enter an appearance and look over this case. We are happy to do so if you would like to enter an appointment order so we can review his post-conviction motions and see if there's anything we can do to help him out.
Can you send me an order down? Andrea,
I'm sorry, Your Honor, I couldn't hear you.
Is there an AOC order form? Where will I get the order?
Would you like me to send you a proposed order, a tendered order?
Send me a proposed order, I'll sign it right away and we'll
Okay.
get you to work on the thing.
Yes, I can do that.
Cheryl, can you help her get the order together?
Yes, Your Honor, and I will make sure that she has all the contact information.
Okay, now we're next here on February the 8th, but since everything's gonna be done remotely here, I will consider you picking one of the other two venues that we have over in Burkesville or Tompkinsville to get him back in front of us when they're ready to get back in front of us, okay?
Thank you, Your Honor.
Okay, thank you very much. Mr. Pittman, things are in operation now, okay?
Okay, thank you, sir. I sent in another motion myself. I sent in one for grounds on the 1142.
Well, you need your attorneys.
Okay, I sent it to the clerk.
You're not on the docket for that today. But
Okay.
we're aware of that. We'll take a look and see if we can find it, okay?
All right, thank you, sir. So she'll be in touch with me?
Janet Owenby there, is she there?
Thank you.
Thank you.
Yeah.
Commonwealth versus Janet Owenby, 23 CR 0035. Are you Janet Owenby?
Yes, sir.
Born in 1962.
Yes, Your Honor.
Digits of social security number 0936. There is an issue here about a competency hearing. What does the Commonwealth know about that?
Your Honor, I can clarify. I tendered the order this morning.
Okay.
Let's hear that.
You just want me to sign an order scheduling a competency
No,
hearing?
she's already been evaluated and we didn't know if he was gonna stipulate or if we had to have a hearing.
That is correct.
Well, somebody needs to tell me about it, you know.
Judge, yes, Judge, we went over the paperwork. It's on me has
Are
agreed
you
to stipulate.
stipulating?
Yes, Judge,
That's
yes.
all I need to know.
Well, you
Okay.
wanted her signature on the agreed order, so he
Is
was
she there?
specific.
She signed it?
Yes, Judge.
Let me see it here. Miss Owenby, I'm showing you that. Can you see that there? Is that your signature on there, Miss Owenby?
Yes, Your Honor.
Okay, well, I'll sign this and we'll get things underway for you, okay?
And Judge, if we could get
February the 8th for pretrial.
and if we could also get that 29th date, Judge, I'm
January
hopeful,
29th for negotiation.
and I'm hopeful to have placement for her by then. Thank you, Your Honor.
Okay, that concludes. I guess we don't have anybody else over at Wayne County, so thank you all as always for your cooperation. Wayne County can be excused. Where's Jamie Ortiz there? What is that? What's Western? Let's go to Western Kentucky Correctional Complex.
Tell them your name.
Bobby Phillips.
Okay, Commonwealth versus Bobby Phillips. Are you Bobby Phillips?
Yes, Your Honor.
Were you born in 1968?
Do what, Your Honor?
Were you born in 1968?
Yes, Your Honor.
Last four digits of social security number 5121.
Yes, Your Honor.
Here for a pretrial conference. Where did Mr. Pennington go? Mr. Pennington. We're hunting your lawyer down here, Mr. Phillips. Who's in rank? We have Mr. Bobby Phillips on the line here with a pretrial conference. What do we have?
Well, we've tendered an offer, Your Honor, and I think it was what the defendant wanted, so we just need to get another date so we can get in the paperwork.
What's the deal on this paperwork?
And this was the one that I had to go meet the victim who's in the hospital, so they.
We don't have paperwork on anything today. Is there something we can do to help you with this stuff, or the Commonwealth needs to be done differently?
Well, Judge, I think one of the Commonwealth's assistants was out, so there wasn't a printer to print paperwork last Friday.
That's correct.
You want to set a different date for Mr. Phillips?
Judge, I'm certain, and I checked with the Commonwealth. I was gonna have him transported today. He hadn't had a chance to speak with the victim yet, so. Yeah, the deal is what we wanted.
Is he a state prisoner?
He is, Judge.
So it won't affect his incarceration, so we can schedule it then for February the 8th. Is that correct?
That's correct, Judge, and I'll tender a transport order today.
Well, he doesn't have to be transported. If he's already gonna be a state prisoner, you're gonna run it at the time. If, he doesn't have to be, you want him transported. Or you need to go see him probably. I mean,
Yeah, absolutely.
you need to go see him and then you can decide whether you want him transported.
Yes, Your Honor.
I'll have him, if he does, it's your responsibility. Mr. Phillips, they say they got the paperwork done on you. They're gonna bring the paperwork down and go over with you so you can see how it affects the service of your time you're already doing and this new plea agreement. Your attorney needs to come down there and meet with you face to face, so, okay, you see what I'm saying? So you can be fully informed about what you're getting into. Then we'll
Thank you.
if you reach an agreement and sign the documents, we'll decide then whether you need to be brought back up here or whether we can just do it by Zoom on February the 8th, okay?
Thank you, Your Honor.
Thank you, and Western Kentucky Correctional Complex, thank you for your cooperation. Y'all can be excused.
Thank you.
Okay, Russell County Detention Center. Y'all will turn your camera on. Russell County Detention Center. Russell County.
Hang on just a second, Your Honor.
Okay, thank you.
Okay, is it on now, Your Honor?
There you go. Commonwealth of Kentucky versus Stephen Bridgman.
Yes, Your Honor.
Commonwealth of Kentucky versus Stephen Bridgman, 23 CR 001. Are you Stephen Bridgman?
Yes, Your Honor.
Born in 1960.
Yes,
Last four digits, social security number 6692.
yes, it is.
Okay. This says there's some motion for shot probation.
Also final sentencing, I believe, Your Honor. I've got the one case and Mr. Mr. has the other.
It's not on for sentencing.
He's already a state inmate, so I believe he can waive his this is a case, Your Honor, where we had filed for motion for shot back in November. You had referred him for an assessment for drug court. They did the assessment. I was not present in December, and so it was continued to today. So we're asking that he be released to go to drug court.
Mr. Stockton?
Yes. The way I look at this case, Your Honor, is, Mr. Nally served about 4 or 5 months in jail and cooperated. Mr. Bridgman didn't cooperate, took the case to trial. He wasn't found guilty on the arson, but he was found guilty on the tamper, and he got a 5-year sentence. He's going to be parole eligible here probably about June because of the 5-year sentence. I know he used to do pretty well in life till he got on drugs. Drug court would be appropriate. I think Commonwealth wouldn't have an objection to drug court because we'd have more control over it, to be honest with you. Yeah.
Yeah, I was gonna say that if you close the judgment order and all that on the other case, that been done signed, and if that closed the case, it didn't vote that. Yeah. So, if you want to do it, sign on some.
If he hadn't been found guilty, of arson, he wouldn't be having it.
And this is also the defendant, Your Honor, that his wife passed away between the trial and the sentencing. Leaving his son at home with no income.
What is it?
Your Honor, may I speak as well on behalf of Mr. Bridgman?
Yeah, we have any other attorneys here that might want to chime in that
Well,
aren't for record? Here, just line up behind Mr. Cross there.
If he's going into drug court, he's getting out on our case, of course. I want to say this about Mr. Bridgman. one of the first clients I ever had when I started practicing law many years ago in a workers' comp case. He has done at times done very well in life. He has the potential to be a good citizen. I think that knowing Steve as well as I do, I think that he benefits much more from the supervision requirements of drug court than he does by simply being paroled. I think that works in his best interest and the system's best interest.
I was really shocked he wasn't convicted of arson. Somebody burned that cabin down and there was testimony about it that directly placed him there, and there were all sorts of circumstances, but he wasn't convicted of arson. But that building was burned down. It was a total loss for the owner of the building. I just can't get that out of my mind. I can consider all the facts I know about the case, even
The other defendant pled guilty to it, Your Honor. Now he pled guilty to it.
I understand that.
Okay.
And you remember what he testified to also, don't you?
Right.
Yeah.
Right. But that was the only evidence that Bridgman was involved, was his testimony.
And he was found not guilty.
Yes, sir.
What was he found guilty of?
Tampering with evidence, Your Honor, the liquor bottle.
I remember. I remember what he was found guilty of. What's Commonwealth's position on this?
Well,
Is there a victim here that needs to be notified?
Mr. Heist is lost financially. He came and he testified. I've not heard from him since. I could contact him if you want me to. Financially, you know, for some people, that'd be a great loss. For him, financially, it's probably not. So I don't know what his feelings are.
That's what with his testimony at the trial, that the people didn't consider the destroying his property very important
Because
he was wealthy.
That was the testimony.
So I just don't want to open up, let people be making decisions on things like that. I will take it under advisement. I do think that there is a valid argument that most people would do better under the supervision of the drug court if they've got a drug problem. I don't remember that, I don't have any information in front of me that he has a drug problem. You know, it wasn't brought up at the trial.
As my role as Commonwealth attorney, I hear things and know a lot of things that I can't prosecute. And that Mr. Bridgman can dispute it, but I know he's had a drug problem for quite some time, either through his family members or through the,
Mr. Bridgman, do you
Yes,
think
Your Honor.
that you would benefit from participating in drug court?
I didn't hear you.
I said, you have a drug problem. Have you had a drug problem, Mr. Bridgman?
Yes,
Okay, and do you believe that you would participate, that participation in drug court would be a good alternative to you to try to address that problem?
yes, Your Honor, I believe it would.
Okay. Okay, I'm gonna grant the motion.
Thank you, Your Honor.
I'm gonna grant him shock probation. And let's see,
5 years from now.
5 years from today. He'll be on probation for 5 years and they'll be over, I guess, him and interviewed and that sort of thing. When I'll let him
No,
out.
he hadn't even said he's been assessed.
Okay. Okay, well, they'll vote on you getting you in drug court. As soon as they do, when they open up for the orientation, I'll let you out if they vote you in, okay?
Okay, Your Honor.
Okay, thank you.
Thank you, Your Honor. That's all that I have. Have you excused?
Sure.
Thanks, sir.
Darian Riddle.
Yes, Your Honor.
Commonwealth versus Darian Riddle. Mr. Riddle, were you born in 1972?
Yes, sir.
Last four digits, social security number 4086.
Yes, sir.
You're here today for arraignment in 23 CR 0062 and 23 CR 0068. Now, were you previously represented in district court by DPA? I'll continue that. Cases. You have the right to remain silent. If you have any questions about this arraignment, your attorney will be there to consult with you. The grand jury of Clinton County has returned an indictment charging you with receiving stolen property and being a persistent felony offender on receiving stolen property. And also theft by unlawful taking or disposition and being a persistent felony offender on that. You understand those charges. I'm not asking you whether to discuss it or whether you did it or not. Understand the charges?
Yes, sir.
Okay. Counselor, you acknowledge the identity of client received indictment, waive formal arraignment, enter plea of not guilty.
Yes, Your Honor, to both charges. Or both cases.
Yeah, waive formal arraignment and reading of the indictment. Okay, I'm signing reciprocal discovery orders. Now, Mr. Stockton,
Yes.
are these two cases, I noticed that are they separate occasions and separate things that were
That's my
stolen?
understanding, yes, one's involving, they're two different victims.
Okay. Okay. We have a negotiation day set for January the 29th at 9 a.m. You're responsible for a transport order. And then the next is February 8th, court appearance, okay?
I'll be over to see you, Darren.
All right, appreciate it, Miss Brandon.
Chris Thrasher.
Your Honor, give me one moment.
Chris Thrasher.
Your Honor, give me one moment. I'll get Mr. Thrasher out due to the nature of his charges. I can't have him with these.
Okay, thank you. Larry, I didn't know you were here.
Quiet, that judge.
Beautiful day out there. It's a nice drive over. What is it? Is the lake really low?
It's still really low. Yeah, I get distracted before they're getting ready to put the bridge piles in.
Can you see it downriver pretty well?
Once you get down, you can.
From the dam, can you see it?
Between,
It's farther on downriver than that.
it's impressive, some of the.
I spent 25 years ago, I started. Can't tell you the number of hours. You know, you got delayed and canceled and moved around. Be hard to stop it now. Won't it? There's still a section between there, excuse me, skip back. Commonwealth versus Chris Thrasher, 20 CR 0087. You're Chris Thrasher?
Yes.
You're born in 1982 and the last four digits of social security number is 2940.
Yes.
Okay, here's for a pretrial conference. Is all the discovery and everything finished in this case or?
Yes.
Okay, are you ready for the trial?
I think we need trouble, Judge.
Okay,
And if possible, a pre-trial also.
okay, we'll do you. Pretrials are a lot easier to set.
Judge, we had talked a little bit before court, Mr. Leverage tells me he's got a motion to file. And I told him I intend to file a motion for change of venue, so.
You agree with that, won't you?
Change of venue?
Yeah.
Not right off, Judge. I like to change.
Yeah, well, you know, we've already tried one case here in this situation that's related to this situation. We didn't have any trouble seating a jury, really. And I don't, of course, it was a pretty harsh outcome of the trial, but that doesn't necessarily mean that it reflects upon where the jury, you'll need to substantiate it pretty well. Unless you have an agreement on that. When you want to file those motions, let's set February the 8th as the date that you, either one of you have any motions. Mr. Lever, do you have anything you need to file or?
There will be a motion on
planning to file.
Okay. And maybe both of you serve each other in time for you to have responses for that and be back here on February the 8th. And on that day, if we haven't reached a resolution to the case. Now, if you need any testimony on that date as far as change of venue, you need to give Mr. Leverage some notice on that so he'll be able to accommodate it after the end of the docket somewhere. You know, it might be during the lunch hour or something like that, so we can get both of you away from here during the lunch hour at least. From what's happened today, we might have a heavy docket next month because we put a lot of things over. Okay?
You want to get that still be judge.
Well, it just depends on whether you're gonna take testimony. If you're gonna take testimony, we'll set a time certain so you won't have to come around, or we could come in earlier than that. Both of you operate on fast time, don't you?
Yes, sir.
And you get up early, I'm sure. So it might be better for both of you if we try to accommodate you at 8:30 or something in the morning. So we hear the testimony, hear your motions and get y'all on the way. That way you won't have to sit here and suffer through the rest of these things. Okay? So we'll just be waiting to hear from both of you, okay?
All right.
Did you catch all that, Mr. Thrasher?
Yes, I did.
Okay, thank you very much. Now, we don't have anything else in Russell County right now, so Russell County, you may be excused.
All right, thank you, y'all.
Y'all have a nice day. Enjoy the drive back.
Here you call them.
Just clean that area over there. We never did get Kenton County. Or Kenton County, there you are, okay. Kenton County Detention Center, Commonwealth versus Cody Chilton, 17 CR 00055. Are you Cody Chilton? Okay, they'll have to unmute the microphone there. The microphone is muted, please. Commonwealth versus Cody Chilton.
Is it
Mr.
unmuted now?
Chilton. Okay, yes, you can. Mr. Chilton, were you born in 1988?
Yes, sir.
Last four digits of your social security number 0119.
Yes, sir.
You're here today on something to do with a shock probation revocation. Mr. Stockton, you want to come around?
I didn't know.
Okay,
Your Honor,
great.
before we get started, let me say, I represent Cody. I didn't know he'd been picked up. I didn't have this on the docket. I really know about it, little about this as anything other than he's got some issues.
Mr. Stockton, tell me what this is about.
Yes, probably wish it.
It probably went to James.
Well, no,
Yeah,
it says it went to both.
Yeah,
Yeah.
both of them.
Okay, that's.
Tell me what's going on, Mr. Stockton.
Mr. Chilton has a 10-year sentence on burglary and fleeing and evading possession of a controlled substance. He's the one that had a DUI charge in Hardin County that's laid up there for 1.5 years. I don't know that they ever disposed of it, so we kind of sanctioned him a while and he kind of floated back and forth. But during the pendency of waiting on that DUI conviction, besides these other problems, he's got a new arrest in Kenton County, domestic violence, assault, and he had 2 handguns with him on his backpack, a Glock 9mm and a 40 caliber Smith and Wesson. I'm asking that he be revoked. If I have to get the officers on Zoom from whatever from Kenton County, I'll do it, but that's my position.
Mr. Cross, you represent Mr. Chilton.
I do, Your Honor. And Cody, you heard what he had to say.
Here, yes, sir. May I say something? May I say something?
Probably better not.
Why don't, what county are you in now? You in Kenton County?
Kenton County.
Yes, sir.
Yeah, okay. I'd better talk to him, Your Honor.
I'd say that would probably be good.
Yeah.
I will reschedule this on February the 8th, Mr. Chilton, to allow your attorney to talk to you privately. You have the
Yes,
right,
sir.
you have the right to remain silent, and if you say anything there, it can be used against you. And also, this will give us opportunity to bring the officers that made the new
They
arrest.
appear by Zoom.
I will allow them to appear by Zoom. And Mr. Cross, if you want Mr. Chilton transported for this thing, you can get a transportation order. Otherwise, he will appear by Zoom.
We'll make that determination, Your Honor.
Well,
Thank
do
you.
it.
Cody, I'll be in touch.
Do it in
All
enough.
right, thank you.
Don't
Yes.
get it the day before, okay? Thank you. Thank you, Kenton County, for your cooperation.
Thank you for your patience, sir.
Thank you. Okay, let's go to the Clinton County Jail, I guess. We have anybody else here in the courtroom?
Judge, we have 2 pleas.
Oh, yeah, we need to clear that area out over there, bring the grand jury in. Bring the grand jury in. All rise for the grand jury, please. Okay, everyone can be seated. Who's the foreperson of the grand jury? Madam foreperson, have y'all completed your work? Have 9 or more of you agreed and authorized you to proceed with your signature on there?
Yes, sir.
Okay, will you present that to the bailiff? You may be seated. Let me examine the document. Okay, ladies and gentlemen, the grand jury, I've looked at the documents that were presented to me. They appear to be in good order. I'm going ahead and sign an order, and we'll determine as we look at these whether we'll have criminal summons issued for individuals or whether we will have warrants. Usually, if they're not in custody, we do warrants with bond on them. It's our responsibility to set the bond and amount to assure that they will appear. And if they're dangerous, to make sure that there will be limitations to protect individuals that might be victims. Therefore, it's very important that you keep confidential any information that you received in the grand jury about this or any other matters for the protection of those who testify. Hasn't happened here in Clinton or Cumberland County, but in some counties around, we've actually had people injured and some deaths where stuff leaked out of the grand jury did. And sometimes people decide to get scarce if they've been indicted, if you follow what I'm saying. So thank you very much. Unless you're called back in case of a special grand jury for an emergency or insurrection of some sort, you'll next be back here on February the 8th. The world we live in, who can tell whether there's an insurrection coming, right? We just don't know. But if you see a CNN and Fox going around the Clinton County Courthouse, you'll know there's been an insurrection. So thank you for your work, and you can be excused. All rise for the grand jury. Thank you all very much. Okay, let's go back to you have a couple of pleas, did you say?
Yes, Your Honor. Let's start with Ashley McCusker.
And who is this you have with you?
Ashley McCusker, 23 CR 49.
I got it here. Commonwealth versus Ashley McClusker, 23 CR 0049. Miss McClusker, you were born in 1987.
Yes.
And it's last 4 digits, social security number 4575. What do we have here? A felony plea or
That was the misdemeanor.
misdemeanor plea? A motion, you can get behind the microphone. A motion been tendered since you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes.
You've previously been identified as the same person named in this indictment. Is that correct?
Yes.
Is your judgment impaired today in any way?
No.
Have you discussed the charges with your attorney?
Yes.
Are you satisfied with his advice?
Yes.
Have you reviewed all the evidence the Commonwealth has against you?
Yes.
You believe you're fully informed about the case?
Yes.
Understand that you do not have to enter a guilty plea today. You understand that? You have certain rights under the Kentucky United States Constitution. I need to know that you fully understand those rights. I'll ask you at the end if you understand it. Okay?
Yes.
You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, the right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to give us evidence, right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, right to part of the Commonwealth, prove beyond a reasonable doubt that you're guilty charged against you. Understand that by entering a guilty plea, you give up those, right? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept. This is a misdemeanor, so I won't have to have a pre-sentence investigation for it. So I'll make my decision today. I accept it based on information I have. In the event that I don't accept the recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Y'all will move to your left. Mr. Stockton, come forward and give them what the Commonwealth's recommendation is.
Your Honor, Ms. McCusker would plead guilty to assault 4th degree, 12 months, probated for 1 year, supervised, and she would enter and complete anger management classes. And I think she may have those already signed up with cabinet. I'm not sure.
But you need some background.
Ms. McCusker evidently had an altercation with her older daughter over babysitting. This is the allegations that's contained from the cabinet. And during the time that they had this altercation, she's supposed to have hit her in the leg with a spatula and cussed at her. That's the allegations of the case. The grandparents who reported this wanted her to be in anger management and didn't want any jail time. And also that's what Sheriff Mark.
Injury?
The picture I've got, I can't make out anything. It's just a red place. If at all, I'll show you the picture I've got. It's by text message. Its quality's not very good. I don't even see anything from that. Yeah. It's my opinion that she probably shouldn't have been charged with felony to start with based on evidence. But that's what she was indicted on.
Is it a probated sentence?
Yes, 3 years supervised. Yeah, no doubt.
Yeah,
And Judge, Ms. McCusker is under a prevention plan with the cabinet. She is still in.
She reconciled with the child lived with her again, or?
No, I've not had I've not been able to have no contact with her because you wrote no contact. You know, whenever I got out of, I guess for the indictment, and so I ain't had no contact with her. But before that, I was getting to see her and all that, but they said they'd give her back to me today, you know, as long as you said that it would be okay.
How's the child communicating with you? Y'all all right?
Oh, yes. I mean, we talked every day, all that. It's just me and her had an argument because I
How old
told
is she?
11, almost 12.
It'll get worse.
And I usually took her phone away from her,
But then I just bought her another phone, so
Do you have any help disciplining? I mean, is her father in the home too, or just you?
just me and her stepfather, but he's been there since she was 9 months old. So it's not, he's always been there, so it's a lot.
And then Ashley, how often are you doing your therapy class?
Oh, every week. They come every week.
Yeah, well, you ever diverted a misdemeanor to a
I
pre-trial
don't think it's
verdict?
provided for the statute.
I know, but people do it all.
I know they do it. I kind of like to follow the law most of the time.
I think that some people think there's a plenary power in the district courts to
We did that.
do that, but I'll go ahead and,
Go back, come back and vacate it.
okay, I'll accept the plea.
Thank you.
And let me tell you something. Corporal punishment and whipping people is a very controversial thing now. You understand what can happen to you
Yeah.
now over something like this. I'm glad you didn't hurt the child permanently or anything like that. I'm sure there are children all across Clinton County and in Cumberland County that would love to train the punishment that's been put on them for what you did, but that doesn't diminish the fact that, you're gonna have to refrain yourself. And maybe the child will understand too, the repercussions of not minding and provocation. I'm not blaming the child because she's just a child.
Yeah, she's just a child.
Yeah, okay.
Thank you, Judge.
Good luck to you. Was that supervised?
Yes, Your Honor.
Okay, you don't need to meet with a probation parole officer. Okay, who else do you have?
William Shekels, 23 CR 52.
Cromwell versus William Shekels, 23 CR 0052. Are you William Shekels? Are you William Shekels?
Yes, sir.
Born in 1979.
Yes, sir.
Last four digits, social security number 9169.
Yes, sir.
Okay, we have a plea of some sort.
Yes, Your Honor.
What kind is it?
Felony plea, Your Honor. Probation.
So what?
A felony plea, Your Honor.
Mr. Shekels, a motion has just been hindered that says you wish to enter a guilty plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Have you previously been identified as the same person named in this indictment?
Yes.
Is your judgment impaired today?
No.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you and are you satisfied that you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea.
Yes.
You have certain rights under the Kentucky and the United States Constitution. I'm gonna go over those rights, and after I do that, I'm gonna ask you to understand all of them. If at any time you have any questions, you can step away from the podium and ask your attorney, okay?
Okay.
You have a right not to testify against yourself. No one can make you say anything. The right to speak trial, the jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, the right to require the Commonwealth prove on a reasonable doubt that you guilty of charges. Do you understand that by entering a plea today, you give up those rights? You understand that?
Yes, sir.
Okay, now I may consider the Commonwealth's recommendation, but I may apply a range of sentence provided law. I don't have to accept the recommendation. Prior to accepting the recommendation, I will await a pre-sentence investigation report done by probation pro. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and go to trial. Mr. Stockton, will you come forward and say what the Commonwealth's recommendation is?
Your Honor, Mr. Shekels will plead guilty to trafficking and controlled substance first degree, receive a sentence of 6 years. He would be committed to Edgewater Recovery Center in Moorhead, which he's already enrolled in for a minimum of 6 months, and he'd be supervised for 5 years.
Is that what you agreed to?
Yes, sir.
Okay. Are you pleading guilty because you did commit the acts charged in the indictment?
Yes.
You plead guilty of your own free will?
Yes.
Know your constitutional rights, so your desire to proceed with your plea of guilty and allow the court to fix your punishment. You understand that by any guilty plea in future convictions of felonies can be enhanced in a persistent felony offender law. You understand that?
Yes,
Is
sir.
that your signature on the docket?
Yes, sir.
Okay, I will accept the agreement or the pre-sentence investigation report. You'll be back here on February the eighth. Now, was the entire sentence probated? Is that correct?
That is correct. Well, once he completes rehabilitation.
Yeah, but he'll be back in rehab. He leave here today and go back to rehab, right?
And Judge, yes, and we were gonna ask, it was a daunting task to get Mr. Shepherd here for transportation. Is there any way he can do final sentencing via Zoom?
I have no problem with that.
Thank you, Your Honor.
You know, or you can go up and get him and bring him back and forth either way.
Morehead's a little further than Manchester.
You think a lot of, hey, Mr. Shickles, in other words, he thinks a lot of you, but not that.
It's 3.5 hours from here.
I've been there many times. It's a beautiful place.
It is.
I hope your recovery goes well.
Thank you.
Thank you, Judge.
Go to the you drive up the Rocky Atkins Road to get to the Rocky Atkins building and turn right and go up the Rocky Atkins stairs. Okay. I guess we're ready to go back down to Clinton County Jail. Is that correct?
Yes.
Okay. Clinton County Jail, if you'll come on. Okay, let's call Terry Britt out first. Arraignment. Commonwealth versus Terry Britt, 23 CR 0055. Are you Terry Britt?
Yes, sir.
You year of birth 1975.
Yes, sir.
Last four digits of your social security number are 0958.
Yes, sir.
Here today for the purpose of arraignment. You have a right to remain silent. Your attorney is here. The grand jury of Clinton County has returned an indictment charging you with possession of a handgun by convicted felon, possession of marijuana, and possession of drug paraphernalia. You understand those charges?
Yes, sir.
Okay. Counselor, you acknowledge the identity of your client, enter plea not guilty, waive formal reading and arraignment.
Yes, Your Honor.
I'm signing a reciprocal order here, sir, that requires the Commonwealth to provide you with the information necessary to prepare for your defense. You'll be available on January the 29th for negotiations and February the 8th for your next trial, your next pre-trial. Okay?
Thank you, Judge.
Thank you very much. John Brown. John Brown. Commonwealth versus John Brown, 23 CR 0059. Are you John Brown?
Yes, Your Honor.
You born in 1979, Mr. Brown?
Yes.
Last four digits, social security number 2532.
Yes.
Okay. You're here today for the purpose of arraignment in case number 23 CR 0059. You have a right to remain silent. Your attorney is here present in court. If you have any questions about the proceeding today, he'll be in contact with you. Possession of your grand jury charges you with possession of controlled substance, the first degree, possession of controlled substance, first degree, another charge. You understand what those charges are?
Yes.
Okay, I'm signing a reciprocal discovery order here. You acknowledge the identity of your client receiving indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pre-trial motions.
Yes, Your Honor.
Okay, you'll be here in court on January 29th and you're at the courthouse for a negotiation day. And on February the 8th, you'll be in court the next time. If you need him transported for negotiations, it'll be your responsibility.
Yes, Your Honor.
Your attorney will be down to see you. Okay, to explain about the negotiation day. Okay, Commonwealth versus Charles Grizzly. Grizzly. It's the same name as the TV star, Grizzly. Commonwealth versus Chrisley the second. Are you Charles Chrisley the second? I need Charles Chrisley. Thank you. Was Mr. Brown trying to say something else? Mr. Brown, did you have anything else? Is he all right? Mr. Brown, I didn't mean to cut you off. I didn't see you trying to say anything. Do you have something else?
Yeah, I was just wanted to discuss bond.
Okay, have you looked at his bond?
I've not, Judge.
What is his bond? Yeah, I doubt if you're out in bond and for 100 grams of meth, so you'll probably have to set a hearing on that. I'll be glad to have a hearing. Your attorney be in contact with you.
Yes, Your Honor.
Charles Chrisley. Charles Chrisley.
Good morning, Judge.
Yeah, hello. Commonwealth versus Charles Chrisley. 23 CR 0061. Are you Charles Chrisley?
Yes, sir.
You born in 1974.
Yes, sir.
Last four digits, social security number 3640.
Yes, sir.
Here today for the purpose of arraignment. You have the right to remain silent. Your attorney is here in Ford. He's way there, Counselor. See him? Okay.
Yes, sir.
The grand jury of Clinton County returned an indictment charging you with burglary in the third degree, criminal mischief in the first degree, theft, unlawful taking a disposition more than $500 but less than $1,000, criminal trespass, and being a persistent felony offender on the burglary and criminal mischief warrant. You acknowledge the identity of your client, receiving indictment, away formal reading, arraignment, or pleading not guilty, reserving all pretrial motions.
Yes, Your Honor.
Setting a reciprocal discovery order, where Mr. Chrisley, where they have to provide your attorney with the evidence to help you prepare your case. You'll be here on January 29th for negotiations and on February the 8th for your next court appearance. If you need a transportation order to transport Mr. Gray, I know he's down here locally right now.
Yes.
If he's here, we'll need to have him brought up probably. Probably need to sign a transfer order or something, have him brought up anyway, okay?
Yes, Your Honor.
Okay, thank you very much.
Judge,
Yeah, Mr. Chrisley, you got something?
could I ask for a bond reduction? I'd like,
Of course you can ask what, just a $25,000 surety.
yes, sir. I don't have anybody to go that surety bond. If I could get a signature bond, get out, get back to work, I'd like to point out that
How much, you have somebody, who you work for?
I work for Detweiler Construction in Elizabethtown. I've been up there.
Surely somebody, wait, surely somebody will sign a surety bond just to get you out. How long you been in?
I've been, it's 3 weeks now, and then I was in 3 months before the indictment came out.
Yes, he had initially served, was released on a 60-day failure to indict and was indicted subsequently. So he's been in, he had been in trials before.
What do you say?
Your Honor,
Wait,
I turned myself in.
Wait just a second.
I'm sorry.
Be staying in Elizabethtown and working up there.
Yeah. Will you be staying in, what's?
Yes, he's on probation at work.
Yeah.
He's what?
He's on probation out of Martin County. They have a camera on, but I think they looked at it and put him back on probation. Mr. Shea.
He doesn't have any business in Clinton, so.
Okay, well, here's the deal. I'm gonna lower it to a $10,000 surety. So anybody who's got a car probably come in and sign to get you out. Well, okay, you can't put the car up, but they can show up. If you got somebody that signed a $10,000 surety to get you out?
I don't know that I do, Your Honor. I don't know that I do. I don't have any family left, and I've got a few friends, but I hate to, I'd be willing, like you said,
Wait just a second.
Berkeley third, Your Honor, criminal mischief,
Burglary?
or criminal trespass.
What are the fact allegations of this case, Mr. Stockton?
This is the case where he allegedly went in and robbed his mobile home over different times. It wasn't being used for residents, but they were remodeling it, fixing it up, and people going in and taking items out of that. And evidently, he's on Hardin County probation, and he was staying down here because he was basically homeless. So I don't know if he's got living arrangements in Hardin.
Where are you gonna live if you go back to Hardin County?
I have a place. I'm staying with a friend of mine in Hardin County. And Your Honor, I reported the day after this indictment came out. I knew I was going to jail and reported to my probation.
I know enough. I know enough.
Okay.
I'm gonna tell you what, I'm gonna make a condition on your bond, except for court appearances. You stay out of Clinton County and Cumberland County.
That's fine.
Okay, now I know that's a hard condition to stay out of this area here, but I want you to give a specific address where you're gonna stay. And wherever you're staying, you're to remain in that residence except for work, church, going to the doctor, grocery store. In other words, you're not to be out gomming around, okay?
Yes, sir.
Okay, and I'm gonna lower it to $5,000 surety bond. Lowest surety bond I've ever set in my life, okay? Now, if after a week you can't find anybody to make the surety bond, your attorney will call the Commonwealth attorney to see if they can reach an agreement, okay?
Thank you, Your Honor.
Thank you.
Thank you.
Okay, Daniel Duval for sentencing. Commonwealth Kentucky versus Daniel Duval, 20 CR 00021. Are you Daniel Duval?
Yes, Your Honor.
Born in 1989.
Yes, Your Honor.
4 digit social security number 3783.
Yes, sir.
Your pretrial diversion was voided on December 11th, 2023. Have you had an opportunity to look at this pre-sentence investigation report done by probation and parole?
Yes, Your Honor.
Is it correct? Is it correct?
Yes.
Okay.
Yes, sir.
Counselor, is there any reason that this gentleman should not be sentenced?
No, Your Honor, but with regards to the PSI, I think it's just a timing issue. It reflects that the charges in Wayne County were pending. He has been indicted on those pending charges since in Wayne County. And there was an older case showing on the PSI that was also still showing as pending from 2007. We'll check on it.
Okay, it'll be modified. Is there any reason this gentleman should not be sentenced?
No, Your Honor.
This court sentences you to 3 years to serve. They give you credit for time served. Okay, thank you very much. Where's this? Thomas Moreland. Thomas Moreland. I'm waiting for you to come on. Huh? Yeah. Commonwealth versus Thomas Moreland, 23 CR 0065. Are you Thomas Moreland?
Yes.
1982.
Yes.
Last 4 digits of social security number 05.
Yes.
You're here today for arraignment. I see your attorney, Mr. Bertrand, is there with you. You have the right to remain silent. If you have any questions concerning thing, you can stop and ask him. Could you get, I don't see a copy of the indictment.
They gave me the only copy, Your Honor.
Okay. Well,
And I've received that, and I represent him in a plea of not guilty way.
he's charged with strangulation, is that correct?
Yes, it is.
And assault with 4th degree?
Yeah.
Okay. Is there any other charge on that, list on that indictment, Jim?
It says, strangulation, second degree, a class D felony. I do not see the misdemeanor. Oh, yeah, I do. Here's the other one. 60.
Those are the only two charges. You acknowledge the identity of your client, received indictment. Waive
Yes.
formal reading and arraignment, enter plea of not guilty, reserving all pretrial motion.
Yes, Your Honor, I do.
Okay, well, you need to be here on the 29th for a negotiation day at 9 a.m. and back on February the 8th for his next pretrial. I'm signing a reciprocal discovery order. The Commonwealth has information up here that they will hand to you in preparation for the negotiations and for those proceedings, okay?
Your Honor, we may not need the negotiation day. I think we've resolved the case. There's a sentence in district court that's on the obstacle, and that will be resolved on the 24th. So if we could just come back to 8th, I think we'd be ready to enter the plea then.
Come back to 8th, but I want you to have the paperwork done. The paperwork's done. He said, Mr. Stockton says the paperwork's done, so if you'll make sure you have the paperwork here on that day, and if you want your client to be here in court, you'll need to do a transport order to bring him up here, okay?
I'll do that, Your Honor. Thank you very much. I'll be excused.
Yeah, absolutely. Jeffrey Reagan.
Very good. Thank you.
Commonwealth versus Jeffrey Reagan. 20-0035. Are you Jeffrey Reagan?
Yes.
Were you born in 1960?
Yes, sir.
Last four digits of social security number 7413. Is that correct?
Yes.
It says you're here on the review. We'll find out what that's about here.
Your Honor, probation and parole. We had a hearing on Mr. Reagan in December, and he had violated his probation, but the court was reluctant to revoke him because of his health. And probation has him lined up for a short-term inpatient treatment at Protea because of his medical issues. And then he'll come out, he'll go through not SAP IOP, but inpatient IOP, I'm sorry. Counseling, if that's all right.
How long is the treatment?
Short term, anywhere from 30 to 90 days.
Okay, is that he had all kinds of medication?
Yes.
And Judge, the only thing Mr. Reagan had asked is, my understanding in doing his intake, that he has to take some items with him, some clothes, some shoes, and some groceries. If he could have some time to go by his home and get those.
We don't have a bed date yet. Bed date's not ready today. We wanted to make sure he was okay.
I'm all right with that. I'll go ahead and sign an order, and he gets somebody, whoever's gonna transport him. Is it a family member's gonna transport him? Who's gonna transport him?
I don't know. You all are.
I don't know.
Well, you need to work that out. And if Mr. Reagan has a family member that's gonna transport him, they can pick him up the day of transport, go out and get the clothes that he needs and run him by a dollar store. There's one on every corner.
Yes, Your Honor.
Okay.
Yeah, I'll let you know. We'll give him like 2 hours to get there, 3 hours. He's
Yeah.
going to Somerset.
Yeah. Mr. Reagan, do you have clothes at your home that you can pick up to take with you, or somebody laundering them for you, or what's the deal?
Yes, sir.
Okay, well, make sure whoever is gonna help you, tell them what you need and that sort of stuff, and we'll let them take you over there and get that stuff and then stop by a grocery. You look like you're feeling better. Are you feeling better?
Yeah. Yes, sir.
That's good. Well, I hope you get cleaned up. Things turn around for you, mister. Okay?
Okay.
Okay,
Yeah.
Michael, they'll be getting with you as soon as they get a bed date. Okay?
They talked to me yesterday and told me they had a bed for me.
Well, they'll give you the exact date. Okay? Okay, thank you very much. Michael Ritchie. Commonwealth versus Michael Ritchie. Mr. Reagan seems a little bit confused.
I was with me, yeah.
Commonwealth versus Michael Ritchie. Are you Michael Ritchie?
Yes.
Born in 1973. Last four digits of your social security number, 4878.
Yes.
You're here for a pretrial diversion revocation. What do you have, Mr. Stockton?
Your Honor, Mr. Ritchie's on, he has a 5-year sentence for wanton endangerment from when he pointed a gun in the direction of Melina Ritchie, who's the victim in this case. I filed a previous motion to revoke pretrial diversion because Miss Ritchie had gotten a plea against him saying that he was holding her and wouldn't let her get to her medical attention. We had a hearing on that, claiming that that was a forgery or whatever. But ultimately, after that hearing, the court ordered that Michael Ritchie was not to have any contact with Melania Ritchie. Well, Mr. Ritchie was arrested on December 18th because he'd been to her residence, had borrowed a car off of her. I don't doubt that he's been having contact with her because since he's been in jail, Miss Ritchie's called me, told me that he's her husband, she's not afraid of him, and she wants him with her because she's having health problems. So the only issue is he's going to be revoked because he violated the court's order, or is the court going to let them have contact? I mean, that's where we are.
Judge, Miss Ritchie's here. She has been in this courtroom a number of times to dismiss the underlying EPO DVO, to try to dismiss.
Is there a weapon involved in it?
The first that caused the entry of the plea.
How long has he been in jail?
Over 30 days. This time since December 18th, when he was called down to her residence.
Is she here?
She is, Judge, and we have a trial set on the violations, February 22nd. The allegations most recently are that he was in a car that belongs to him that he has keys to.
There's a district charge for violating the EPO, DVO, and district code. And that's.
Well, I'm just gonna wait and see what happens there. Still waiting, that's the jury's.
What does he mean by that?
You can't say you can't be with your husband, you ain't gonna be in jail.
I mean, what does he mean by jury?
What do you mean by jury?
So I go to court on Tuesday to have the EPO, DVO amended
Well,
or to dismiss.
right, they told me there's a jury trial set for it. Is that correct?
On the alleged assault and violations of the DVO, EPO. Been trying to drop for 6
Well,
months.
I don't care what she's been trying to do. I try to fly and I can't do that on occasion. Right now, there's a pending case in district court that's gonna be tried in front of a jury. Now, if you can get the prosecutor to keep the Commonwealth from protecting you, if that's what you want, if you don't want the protection of the Commonwealth, and you want to subject yourself to a continued relationship, there's not much I can do about that, but I'm not gonna do anything until I find out what that jury does or see what the district court does. And I'll probably go along with whatever the district court does, okay? Okay, thank you very much. Joseph Wallace.
Wallace.
Joseph Wallace. Commonwealth versus Joseph Wallace, 22 CR 0017. Are you Joseph Wallace?
Yes, sir.
You born in 1976?
Yes, sir.
Last four digits, social security number 4672.
4673.
4673.
Yeah.
Okay, I'll make that change. You were here on a probation revocation hearing. You're representing Mr. Cross. You step to the left, Mr. Cross. Mr. Stockton.
I just briefly tell what the court is. We need testimony. Mr. Wallace has been absconded since June of 2023. And in August of 2023, at the address he was supposed to be living with, Angela Wallace was arrested and she had 45 grams of methamphetamine possession. So that's the two bases for a revocation.
Your Honor, we're prepared to stipulate that he absconded. I believe that
We'll
means.
stipulate and we will revoke the probation, and I guess the time he's got will be good, good time, I would assume, correct?
Yes.
Okay, thank you very much. Is there anybody else that the Clinton County Jail that's on our docket here today?
No, sir.
Okay, well, you're excused. That concludes the criminal docket of the Clinton Circuit. Thank you. Okay, let's come to order, please. We call the child support docket. Van Winkle versus Van Winkle.
Judge, the respondent's ordered to pay $207 a month on current and 25 on arrears, and we're asking that 1,000 be paid by February the 7th. The arrears is getting a little big, so we're asking for real big, so we're asking 1,000 be paid.
Purge himself if he gets arrested and pay $1,000.
Yes, sir.
Stinson versus Johnson.
It's an error.
Oh, that's not us, Judge. I'm not sure what that one is, so.
Asbury versus Asbury.
Judge, this is a motion to reinstate child support. Previously, non-custodial parent was previously ordered to pay $299 a month on current and 60 on arrears. And the case had been closed, but they've requested that we collect again.
Cabinet versus Judge.
Judge, we're passing that motion.
Who's that?
We're passing that motion.
Craig, Cabinet versus Craig.
This is a motion for default judgment. We'll have Stephanie just testify to the service.
You raise your right hand, swear to testimony best gives the truth, whole truth, nothing but the truth.
I do.
State your name.
Stephanie with them,
By whom are you employed?
Clinton County Child Support,
And what is your position?
caseworker.
Are you familiar with the case we're here on today involving Vanessa Craig?
Yes,
Okay, and what's been your involvement in that case?
I've been a caseworker in this case.
Okay, and has Vanessa been served?
Yes,
What was that service day?
October 30th to 2030.
Okay, has any response been filed to your knowledge?
No response.
Okay, are you asking this order to be entered today?
Yes.
Okay. Shelton, Cabinet versus Shelton.
Your Honor, in this case, the non-custodial parents ordered to pay $291 a month on current, and this is to set child support, Your Honor. So we're asking $291 a month be ordered to pay, and the worksheets included with the order.
Cabinet versus Rick Ford.
So we have an agreed order, Judge.
Cabinet versus White.
Judge, we have an agreed order in that case.
That concludes your document.
It does, Your Honor.
Okay, thank you very much.
Thank you, Judge.
This.
So I'm gonna get inside.
No. I think it's just- it's such a good line.
Well, I know you can't pass a certain part. What are you doing over here? Y'all get that thing undone? Well, that's what they've got a mess on their hands. Hey, I knew it's gonna be like this. Look, Jay, you remember one day tried to push, think it's the Arby's, was like, grief. They tried to take it out, maybe 20 years ago. It's that one, it's on for me. And it went all to pieces and they gave up on it. They gave up on it, million dollars. Just a while. Now they shot it. Now he's out to the source. What are you gonna do? Does it work for y'all? Are they hooked up PDA's office, which in the system? It's certain. See what they or they go back downstairs. That's what it is.
If we think it takes a lot. Nobody likes me because when I do that, I want to. I guess exercise, not the children, well, but you know. Maybe by the time we get home, a lot of things, minutes to sit down and chill out, but you just think that energy. No, I don't know. She wants out, she can't park. So you don't think it's gonna sign the other thing? I'm just gonna say, that's what I agree, what we agree, and on the record. But I did cover in her time, because I said there was certain issues. We probably should just sign it, that was my fault, so I was like. So change. Yeah. So they went in and I think they had lunch at local offices. They're good, I'm sure about children. They told me. Seriously, it's bad. Of course. Now, how many years have been?
She's strong.
I said, her girl.
I know you might not say it now. Well, the only exact name. But they play on the rest of the waking up here. Somebody somebody being nine or playing all that's obviously that's the change. Scary. Because now they handle it. Brown. Yeah, they can. We've been, and we've been. And it still scares me that maybe we looked at that because of the sheet. But we have been. I'm gonna see what you had to consider ever since. The law has changed. They shouldn't see. Outside you got, because instead of going on social media, he was hired the car and said, "Oh, we got custody. You need to get the ball." And it worked, and it worked. He said, "I want the ball." Went to the.
He give it all to him.
Went to the. He said, "I want the
She
ball."
didn't keep none.
And it didn't come out. But he had done it for weeks, like when he started.
So I told Brown, I said, I tell you,
Once with this, a surgeons of CD language, they said, "Give me the ball."
Yeah. The way I explained it, was 27.
Boss ball, I was.
You'll figure it out.
Almost got straight out of football. Maybe it's just.
Last
year's job, which we're looking at the device stuff like that. He's sitting with one of the guys. He did stories of San Francisco. But he still does. So it's just better. Small. I was the biggest critic of McCarthy is you can people that treated that to McCarthy.
Yeah. You got that much shirt. We all make it, bring back.
But this year, actually, so much.
I don't know, the one that has Ainsworth in South Carolina.
Well, I was telling you, well,
Didn't take as long as I think. There's a lot of names.
of course, you know, I'm. That's bolts on the Charleston. There's some guys that's done some breakdowns of how McCarthy is really masters. And they went back and showed here's what he did Green Bay, and then they showed the Keller Moore and said, here's what Dallas does with this defense. I look at the routes that look like it. Part of it, it's all designed to put specific defender in the zone. He's constantly put one guy.
That's what I.
In conflict of what the right is. I'll cover this guy or I'll cover this guy. And obviously, he's told back that it's 1, 2, 3, and then this route, this coverage, this is the conflict guy. And you're gonna read this guy. And if he comes down, you throw it here. If he stays back, you throw it here. Yes. Well, I mean, the thing about it is everybody's thinking this is so submitted. Well, not really 20, let's say the last 10 years. He was all out of his head. I've heard of those. And that's the reason he even though they won a Super Bowl, Bruce Arians is the head coach. That's the reason was Arians. Was Arians, no risk, no risk, risk it the biscuit. But he was throwing too many downfield rounds. It like you hold like a ball. But he kept running around. Well, that's the thing. You can't cover something.
I don't know. I don't know if you guys can beat that.
Well, no, that's fine. No.
I mean,
Yes, sir.
I mean, it was.
Well, because there, that was the thing. Zach threw 3 interceptions because he was under pressure and he was getting hit. He was having, he was making up wrong reads, but he's having to get rid of the ball.
Shooting Johnson.
That's about the only thing that's stopped. When he's been down, they feel. I mean, they have.
I still think Dak should have been the MVP though, because if you look at the numbers, Dak was gonna see stuff. Every single category. So come on.
It'll hurt him.
Well, and he got, I think he's prone to. Well, I think ultimately, that's why it's very sad. It's like. Which is the best running back he's all.
You just be better doing
It's like, you know, I guess let it so. I've always said this. Mac Jones. Two best receivers in college football. I mean, they're all pros. And the fellow, he's got both of them. There's a Tim Tebow. I mean, Tim Tebow had Hernandez and Percy Harvin. There's another. All of them were all pros. I mean, a lot of times who do, but that's also though. Who do turn out to be some of your really good quarterbacks. And then I mean, Bush Parker. I didn't how do you come up with that? He's doing all nothing. That's right. Because there guys one of them.
Yes.
It's true. We can go on now, Steve Young. 24/7. I used to have a long list that I could rattle off, but there's a lot of guys that played on relatively average college teams that are graded as a. Well, you look at Josh Allen, he played wild.
They were dead.
They were?
2 months ago.
Picked up his side of my Cowboys. As all the and Buffalo.
They never went so big.
Yeah, but that's like Sean McDermott's like playing for Lawrence Stokes. We know you was even close.
West Fire kid today. They will put up with what's like that. They switch. You sit
You're gonna end up in close games.
You'll end up close games.
Because you're not gonna blow. Stoops is gonna shoot. You have a chance to win.
Tennessee guys, yours.
Problems, a lot of times that makes
Make sure I sign. No, don't honestly be about this.
I think it's their, well, have you been watching the stats and stuff on Washington? He's not having holding it on him and 6 weeks, 6. I didn't say, I'm sure my phone, that's like. I'm sure such a guy that's looking good stuff. Only 20 years, like 30 holding penalties on him that have not been called. And they're not like, they had him. Yeah. Dog, they double him. I was taking that reply. He's pretty very. To be as fast as he is, he's a strong. Let's go on the rest. Okay, let's go on the record. Ms. Johnson, I think that you're there. You had 10 CI 0020 and 12 CI 00175 that you were asking for the firm to be relieved, draw as counsel. Is that correct?
Yes, that's correct, Your Honor.
Okay, well, I see that you submitted orders and I'll sign both of them. Okay?
Thank you very much.
Have a nice day.
Thank you too.
Porco propane versus one others. Porco. Don't, you familiar with the ad?
You want to see your cross turn green and grow, use good work.
Yeah, Porco. You got a good judgment for citing that, so. What have you got, Mr. Carter?
Your Honor, we were here on the 7th of
Remember
December.
it just like it was yesterday.
I know you do. And the court at that time suggested we try to settle the overall matter, and we have not been able to do so. So I'm back here asking for the court to enter an order saying we can cash the $34,000 check and it won't settle the entire case. I think under the Morgan case, this is what we need to do. And I don't know if we'll ever collect a penny off of anybody else. We may not pursue it, but we don't want to be foreclosed from attempting to do that.
Your Honor, as far as the check and cashing the check goes, I don't know what argument to make on that one. If Mr. Cross wants to cash the check and proceed to try to get a judgment for the excess, I'm sure that we would raise the issue and say that by cashing it, they had accepted the payment. But I think that we're going to have an argument as to the finality of the payment of the $34,000, regardless of whether he cashes it or not. I think.
Well, that's why we're here, settle it now and not later.
Well, let me ask you something. What's your dispute with 34,000?
Your Honor, my dispute is that these funds were paid from the proceeds of a closing. Mr. Little, acting as the closing agent at that time, contacted Porco. From an agent of Porco, received this amount and was assured this was the payoff of the amount that was owed to them. So the check was written for that. So my client, Ms. Capp's client, both have reliance on that statement from Porco that that was the amount that was due to them. I think that would be our defense to anything.
If the amount had been $60,000 and that check was for $60,000, where would the additional $24,000 have come from? Who would have been entitled to those proceeds, and who has those proceeds now that wouldn't have had them if the $60,000?
Well, Your Honor, that was paid. I wasn't there for the closing. I'm assuming that was paid to the LLC as owner of the properties, and I'm not sure how it was distributed after that. I didn't have a part in the closing.
LLC? Did your client own?
My client was part owner of the LLC.
Was your client part
My
owner?
client was part
And
owner
who-
as well.
and-
Mr. Gibson's client was also part owner of the LLC, and I'm not sure where Mr. Gibson is.
And therein lies the issue too. Of course, I wasn't involved in the divorce action in representing Mr. Riddle because of a conflict, but the issue is, I don't know the time frame of how that agreement was signed relieving her, Mr. Gibson's
Okay, well,
client.
see, this is neither here nor there, Porco. This agreement between these other
Yes.
parties.
But what I'm saying, Judge, is I don't know if that was signed in the course of the closing happening and that was the liability that addressed all of that because they had already gotten the amount from Porco. So that's why I think that aspect is relevant.
Well, do you have any case law that Porco, if they did get the wrong number, Porco did get the wrong number, that it extinguishes any debt over and above that?
Well, I mean, I think when you go
No,
to,
I don't want to know what you think. I want to know if you got any law on it.
well, there's law as far as the doctrine of estoppel and detrimental reliance.
And again, that's
What's
why-
the difference? I don't see how they would rely to their detriment on that if they receive the proceeds over and above that.
Well, but if they relied on the information from Porco that that was the amount that was due, and they allowed for those proceeds to be withheld from Mr. Little, who was the closing agent, then they assume that debt has been paid and they have relied on that. I mean, that's where the detrimental reliance comes in because they're relying on that closing agent to get the payoff from Porco, from the agent of Porco to provide the correct information for the close.
Their action would be against Mr. Little then.
We're not going to pursue Mr. Little. He was in the dark. And the problem was they didn't keep Brett in the loop. They didn't keep anybody in the loop.
Well,
It's not his
I wouldn't
fault.
suggest that anybody proceeded against Mr. Little. But the fact that Mr. Little made a mistake should not keep Porco from collecting their money. I'm just wondering, go ahead.
Your Honor, if I could, I'm not sure that Mr. Little made a mistake. I think somebody from Porco might have made a mistake. But again, that's the
How do you
information.
know that?
Well, I don't know that for sure, Your Honor, but
I have to deal with for sure.
Mr. Little conveyed the information that was given to him from an agent of Porco, and I think Porco's bound by that number that they gave. And I would echo arguments made previously about how they detrimentally relied upon.
What's to their detriment? I don't understand. I mean, they owed the money. If they did owe the money, I don't know that they owed anything. I don't know that this is not the total amount. I don't know. I'm undecided. I hadn't made my decision. But the fact that someone gives you a wrong, if that money, if the proceeds had gone to another party, except the parties that owed the money, and therefore, because of their reliance, the money was not recoverable anymore because a third party had gotten and left it. I would buy into what you're saying.
Well, Your Honor, I think of it like this. If an individual were to go to purchase an automobile and they were told a price for the car and they paid that, and then with whatever money they had left over, they spent that on their other needs or wants. And then the car company calls back a month later and says, we told you the wrong amount. You owe us X amount of dollars more. Isn't there detrimental reliance on the first number that was told to the individual?
But they were dealing directly with the car dealer and they had a deal on it. I don't think that's a good analogy. That's interesting, but I don't think it applies to this case, but I understand that. And if you had a direct deal with someone, you bought somebody and they said, oh, they didn't charge enough on a piece of land or anything else. But when you have someone that is a closing agent or something and calls somebody and finds out they're closing, I don't see how that creates a defense against the number being wrong from the person that allegedly provided the numbers to the closing agent. I don't know.
Judge, and I think by Mr. Cross's own admission, an employee, which is an agent for his client, is the one that provided that information. I'm not saying we need to pursue.
Mr. Cross.
He did on the record in court.
Your Honor, Tracy Hay answered the phone for Mr. Little and looked on the computer and gave her a figure. That figure was what was simply on her computer. She hadn't been working there long. The difference in all of this, from what Brett's analogy is, and all of these people, we caught it in time. If we'd have cashed this check, I wouldn't be here today. It'd be too late. Okay, but we caught it in time because it was an error. It was a mistake. So all we want to do is cash what we've got, and then we'll determine if we want to try to collect off 1, 2, or 3 of these defendants. How
much money is the deficiency?
It's to be determined.
Well, I mean, you can't come in here if you don't know.
Oh, I know. It's about $66,000 total.
More?
No, about 32,000.
32,000.
But as we said in open court last time, I think we would be happy to resolve the case for a whole lot less, but they don't want to pay.
What is a whole lot less? 10,000?
They won't pay.
Judge, I've spoken with my client. It was his understanding that Forco had provided them with that figure. And that's what he thought was the amount that was going to be paid. And he thought this was all resolved. So he's not.
He didn't know how much she owed Forco.
No, because that's the other issue.
Who's involved in the management to make the decision of what they bought?
I guess that goes to both of the individuals running the LLC, which is no longer.
Who were
I
they?
think there was an issue with
The
administration.
individuals in the LLC, Your Honor, my client Joshua Renault and Ms. Cap's client Dwayne Riddle. I do think that Mr. Riddle probably handled more of the day-to-day operations because Mr. Renault is on the road a lot for work.
So
I'm not saying anybody's.
So if I owed, if I owed somebody $66,000 during a close and they quoted 30-something thousand dollars. And because they made a mistake even before they cashed the check, I'll be able to enrich myself and not pay them for the $30,000 based upon that reliance.
That's the other issue, Judge, is they continued to leave that account open and accruing interest once there was some type of agreed order as to what the amount would be for the sale of the property. So then I think you've got to follow the statutory limit on interest that's claimed as well, and we still don't know that.
Interest?
Oh, I'd say half of it. That's just an estimate. I have to figure.
Your Honor, the other issue was at certain point, and this is nothing that was ever set in stone agreed on, but there have been discussions about being able to take care of this debt by paying the principal only on it at certain points. Again, there's no agreement to that, but that had been discussed. And
A
so,
lot of people would like to do that.
but Your Honor, I do think that there was a reliance on the part of these gentlemen at this closing that the number they got from Borco was the final number.
Judge, as stated previously,
Should client pay fine?
Brett and I were on the same common ground on this thing. He was supposed to let me know about the closing. We were going to try to determine a figure to be owed. His people didn't tell him, and nobody told me, and nobody told Gary Little. So here we are.
To be frank with the court, I can't say I didn't know 100% about the closing, but I think I did find out the day before, and I already had obligations to be informed.
And I can say I knew nothing about the closing.
So you're not gonna have to chip in on the money then?
No.
If we could just get an order allowing us to cash the check today, then we'll figure it
Well,
out.
yeah, well, here's the problem is that gets you out of it, but that doesn't help me any, to resolve the rest of it.
Well, Judge,
So I will tell you that and give me an order that you have preserved your issue as to whether acceptance of that check is payment in full or not, and go ahead and cash it, okay? Give me an order to that effect, and then we'll reserve it. But I'm not saying ultimately I won't rule if that's not payment in full, but you could lose that way anyway. I'll just say that it will not be determinative in my finding on whether it's payment in full. You follow what I'm saying?
I understand what you're saying, but in the interest of economy, judicial economy, then if we don't know that we can collect any other monies on this, why would I want to try to spin my wheels and try to obtain a judgment against these people?
That's why I'm asking y'all what the law is on it. I'm trying to determine, but I can't decide that here based upon facts that aren't really on the record, but just on arguments or no law. But I can tell you that you go ahead and cash that and it will not prejudice you in my decision concerning any delinquency in that account, okay?
Yeah, I do think under that Morgan case, we've handled it the way we're supposed to. We caught it, we come into court and say,
Well,
that's why we're asking.
that's the reason I'm telling you to do an order to allow you to cash your check without damaging your claim for the balance of the account you say is owned. And I'll let y'all take proof on it and submit it, or you can try it on a bench trial, or you can take it in front of a jury if you want to. I can't decide it. I've got no law except, these sort of things on detrimental reliance and estoppel.
So
maybe we ought to put the rule against perpetuities in there too, while we just can't get all those obscure things, okay?
I'll tender an order.
Make sure they see it.
I will.
Let Mr. Little see it too, so.
Mr. Little's not here. Mr. Little's not in the case.
Okay. He's fortunate.
Judge.
Okay. Okay. Catherine versus Anderson.
Good afternoon, Your Honor.
Hello.
I'm standing in for Allison Adkins this afternoon. This is her motion, I believe, for review. The parties have previously been before you. And I believe my understanding was Ms. Anderson was to get one supervised visit per week as she's now attained sobriety, and the parties were to agree on a supervisor. The problem is they cannot seem to agree on a supervisor. There's been two proposals. One has been Ms. Anderson's mother, who is actually a social worker in Indiana. I'm unsure what the objection is to that. And the second proposal was her support person at the sober living facility where she's staying and receiving ongoing services.
Where you got, Mr. Cross?
Your Honor, my clients have been
You
reluctant.
move to the left, let Mr. Cross.
Yes, Your Honor.
My clients have been reluctant to, for the monitor or the supervisor to be someone who's so closely associated with Ms. Anderson. I believe the court probably just ought to go ahead and make a determination, and if that's satisfactory with you, I'll tell them to go by it. But we don't think it ought to
What's the
hurt
problem with
family.
their mother?
People said they've had great difficulty with her in the past. I have no details other than it's been a
Where would
conflict.
the visitation take place?
Your Honor, my understanding is Miss Anderson's mother is going to come down here to Clinton County, so that
Where?
visitation.
Where?
Any particular place in Albany?
Like the park or somewhere.
The park or some other
It's not
location?
cold to be in the park.
Right, a public location,
Yeah.
library?
Yeah.
I can't see very much harm that could happen at the public library. Just go in there, and,
As long as it's a public place, I'll tell my people that that's just what.
I'd rather have it where some other people are around. You know, I'd rather have it like at the libraries.
You'll just let me look at it.
Yeah, certainly.
Okay, thank you very much.
Thank you, Your Honor.
Steve Bayer versus Gary Wallace and others.
So Mr. Wallen was filed that, we objected, and it's passed on February 8th.
White Herald versus Storm Resources. Hello.
I was Clint Willis, the Attorney General's office. We filed the motion. I think it's by statute. We're allowed to intervene. That's the only thing.
We
that's
have
on
no
there.
objection, they're entitled.
Yeah, no objection, no. Should just send me an agreed order, y'all only got to visit, have this great visit with each other. But you submitted an order electronically,
right?
Okay, thank you very much.
Thanks.
Medical Center make sure I sign it later. Medical Center at Clinton County Inc. versus Journey Pure.
Morning, Judge. Afternoon, Judge.
Oh.
This is Journey Pure's motion, Judge. As you know, we've been here.
To reconsider.
This is not the motion to reconsider. We've been here a couple times on the motion to reconsider, the entry of order. This involves an emergency motion that we have filed, Judge, because they filed a judgment lien, on the order that the court is still not ruled on. And that judgment lien has caused our client to actually be in default on some of their other debts, and also has actually hindered us in even being able, if we were to resolve the case, to finance to pay a lump sum because of this judgment lien. They filed the judgment lien, Judge, of record in Bowling Green that's attached now to all of our client's property, and it's our position. This is not a final judgment. It didn't have the language of finality in it, that's made it final and appealable. Also, it had this motion to reconsider still pending, which makes it not a final judgment. We've submitted in our brief, Judge, some law, that clearly shows that, without a final judgment, you can't file a judgment lien and attach everybody's property. And, that is Duval versus Clay. And it dismissed and removed the judgment lien because there were pending motions, or motions for relief relating to the judgment that the lien was filed on. And this is our motion asking that this court.
Would you need to file some kind of bond if you wanted relief from execution?
Not until it's a final, that you're referring, Judge, to the supersedious bond, that's on a final judgment. And you file the notice of appeal, you have to file that bond under that rule. But this isn't a final judgment.
So and you might very well be correct, I'll reserve till I hear all argument, but let's say I file a judge, I sign a judgment. And then you come in and file a motion to reconsider and put it off to the next rule day. In the intervening time, you get rid of all your assets. Is that a problem? How would they be able to execute on anything if you could never file a lien if there was a motion to reconsider it?
Well, Judge, I think the law is clear.
Well,
You can't file it that at that point in time.
That's something the legislature need to take a look at, isn't it?
Maybe so.
They could never file.
It has to be a final judgment.
Well, I'm asking you, they could never file a lien as long as there's a motion reconsider or anything, or set aside?
I think the law is clear on
What's
that,
your position? Okay.
that they cannot.
Go ahead. Mr. English.
It's, Lance, I don't want to. I'll move out, get it out of your way.
Judge, if a motion to reconsider is filed within 10 days under Rule 60.02, Mr. Turner's correct. There's nothing we can do. Got to wait till the court rules on that before we can do it. But that's not what happened in this case, Judge, and that's not the law in this case. They didn't, even though they were before the court at that time, they didn't file a motion under Rule 60.02. They filed a motion under Rule 62, which is a motion to reconsider the default judgment. Their motion to reconsider was not filed within 10 days of the date that the judgment was entered. Therefore, that judgment is final. We do have the right to proceed to file a judgment lien. The court admittedly could reconsider. If you set aside the default judgment, then and there is an order entered setting it aside, then yes, we may have to do something or release the lien. But by virtue of the fact that they didn't timely file that motion under 60.02, we have every right 10 days after the entry of that judgment to go ahead and file liens. And that's exactly what we've done. Judge, all we've done is filed a lien. They filed this motion today to hold me in contempt. Said I've committed a criminal act by filing this judgment lien. And you know, here we're in a situation where Journey Pure, after we have gone through time and time again, let them know of the lawsuit, let them know of the fact that we had this motion, served them with the motion for default, never showed up, never did anything. And then we come in here after all we do is file a judgment lien over with the Warren County clerk, and they're claiming that I should be held in contempt and I don't know, Judge, put in jail or something.
Well, that could be true, but I don't think over this matter. What's your response?
Judge, his 10-day rule only, that is 59.05. That is a motion to alter, amend, and vacate that we do all the time after a jury trial or a judgment. That is where the 10-day rule comes in. It's 59.05 when there is a final judgment. We got to file it for 10 days. We got 10 days to file it. But this is not a final judgment. So that 59 and 59.05 only applies to final judgments. It clearly, the rule says a motion to alter, amend a judgment or to vacate and to enter a new one shall be served no later than 10 days after entry. And the rule specifically says final judgment. So 59.05 and that 10-day rule does not apply because this was not a final judgment. They're the one that prepared the order and sent it to you to sign. It did not say it was final and appealable. It had other parties in this suit that were not even served. So there's no way it is a final judgment under 59.05. That is why the motion was filed as a motion.
Those other parties can be jointly and severally liable for a judgment, is what you're saying.
Absolutely. Well, and that's what they asked for.
So that doesn't preclude a judgment being effective again in full amount against any one of them, does it?
But it's not a final judgment under that rule because it doesn't deal with all the parties, rights.
You want to jump in this, brother?
This is very eloquent.
I'm enjoying a lot.
CR 54.01 defines judgment, what it is. It does not have to have the quote unquote final and appealable language. It says that a judgment is a written order adjudicating a claim in an action or proceeding. It said all right. It says a final and appealable judgment is a final adjudicating all the rights of all the parties. Now, as occurs, Journey Pure Bowling Green LLC we got a final judgment, Judge. We have it. If at this point in this proceeding, we do, and we have every right to protect our interest. And that's all we're doing, Judge. We're not trying to sell property or anything else. We're just protecting the fact that this court.
Did you go after any bank accounts or anything?
No, sir.
But they can once they do that. But Judge, he's blurring the lines there. He read you the definition of what a judgment is. And then he went on to call it a final judgment. When the rule says that the lien, you can't just file a lien on a judgment. If you entered a summary judgment or something like that, unless it says final and appealable and adjudicates all the rights of all the parties, it is not a final judgment. And the rule on judgment liens only applies to a final judgment, that you can only file the lien because you don't want to run around and put a cloud on people's title when you don't have the final judgment, because just as he said, there's still a motion to reconsider pending. He's filed a judgment lien that has clouded all of our clients' property interest in.
How quickly did you file a motion to reconsider? How many days?
From the entry of the written order.
Of the judgment.
13.
So you missed 10 days, if the 10 days apply.
Obviously, I believe the 10 days don't apply. Yes, 13, it was 13 days after the judgment, but it wasn't a final judgment. And 5905 is a final judgment that kicks into 10 days.
And the statute on judgment lien doesn't say that. It says that if you have a judgment, you can perfect it by filing the notice with the county clerk in the county where the property is located.
But the case law that we've submitted, Judge, defines that the judgment lien can only be filed on a final.
And that's under a rule where they filed a motion to vacate, alter, or amend following the 10 days. That's what that case held, is that if you've got a motion to vacate, alter, or amend that was filed within the 10-day window, I can't do anything. It would be inappropriate for me to file it. They filed it 13 days. Granted, this court can set aside a default judgment. I'm not saying you can't, but having not filed it timely, I've got every right to protect the judgment that we have that's on a debt that these guys owe and haven't paid, Judge.
It's greatly disputed on the amount of, if anything, that we would owe. We also have to remember that this was filed really quickly after counsel was made aware of the entry of the judgment. And those motions were filed within days of counsel finding out. It was the discrepancy in regard to the clients and the client's misunderstanding. We've already argued that with the court. But Judge, I would once again say, the Duval case, which we have cited to you, which he says it was filed under Rule 59, the actual holding of the case says that where a judgment lien was dismissed by the Kentucky Court of Appeals in this case, when the lien was filed while a motion for relief from the judgment was pending. And that's exactly what is here. We had a motion to reconsider pending before the court when they filed their lien. And Duval, while it was filed under 5905, it was, Mr. English is correct there. The language of the court discusses that it's file a motion for relief from that judgment is pending, and before a court, you can't go file a judgment lien.
Judge,
I didn't set aside that lien. I mean, that judgment, the default judgment, like it was a default judgment.
Yes, sir.
In order to give your client an opportunity, in my own mind, to settle the case. They evidently don't want to settle a case.
Well, evidently they don't either.
Or somebody does, and I haven't heard whether there's been any negotiations or anything.
We have negotiated.
Yeah, I don't know whether they're any closer to that, but I hate to do an order overruling you on the motion set aside, but I'm not inclined to set aside. And I would suggest probably that the next thing that's coming is either a judgment on the pleadings or a summary judgment motion on everybody else. I don't know where you are. Are you taking proof on any of these other defendants or?
No, sir. In fact, right now,
You think
there
you've
are
got, you
many-
think you've got a lien on the people that
I
got the
think
money?
I've got the lien on the right entity at this point, and I don't think, just that they have all these different corporate entities and that they're all the same.
Kind of shell companies?
I wouldn't, Mr. Carter's fine.
There is a nationwide debate going on as to what a shell company is, right?
And I'm not gonna argue that it's a shell company. I just think we've got a judgment lien. All we're doing is just trying to protect what's owed to us under a contract.
Well, I'm gonna overrule motion to set aside the default judgment and also say that because of that inclination, I'm gonna say the lien is valid. So just do an order and then I put final and appealable on that, and you can take it up and you could have a case on it. Okay, thank you very much.
We'll get a judgment.
Thank you, John.
Yeah.
I'm going to bond, but it's all right.
McWhorter versus Hooker. I went to the DRC to.
This one to the DRC.
I don't know, what kind of motion you have?
Most of the custody.
Was the other party present?
Yeah.
Yeah, make sure she knows.
And the answer is fine.
They canceled school in Wayne County Friday and Monday.
I wondered if that was coming. Also, Clinton County, Wayne County, you're getting run.
Yeah.
You think she knew, thought she was going down to the commissioner's office or what, anybody tell me? Is it your client's motion?
Yes, Your Honor.
Well, she was here earlier, so we'll continue to try to look around, send all points out on her or something like that. Okay, we'll pass over.
That's fine. Thank you.
Laura Haddix and others versus Nancy Harden.
I've tendered a thought judgment and orders. I'm sorry, somebody's coming around it.
Tell me, give me a thumbnail for the record on this.
Your Honor, this is our motion. It's combined indivisibility action and a suit to enforce judgment liens. And we are, we'll just tender a judgment order, say.
We tried to pay him several times and he will not take the money.
Okay, what's your name?
Nancy Harden.
Sorry, somebody called.
Nancy Harden.
Okay. Where do you, you're Nancy Harden and husband Ernest Harden?
Yes,
Yeah,
I have paid someone that.
yeah,
And
well, you need to speak up.
I have paid on that and I only owe just a little on that.
How much you trying to collect?
Your Honor,
Is
it's
this
far more complicated than Ms. Harden understands.
Um,
Number one, if I may, you
Move
have me
over
with
here just for a second and I'll let you come
Okay.
back.
Number one is the Haddix estate was owed money by Ms. Harden and her sister. Her sister's paid her part. Ms. Harden has paid some. She's credited for all that. Number two, David Cross has a lien on Tony Albertson's part. I want my money. Number three, Stephanie Myers is joined it as a plaintiff and wants it sold for indivisibility. So there's nothing she can do to stop it.
Stephanie said you was shoving her to sell it.
Do what?
Stephanie said that he was shoving her to sell it.
Well, that's, then he.
And are you
He
allowed-
accomplished that then. So.
Are you allowed to?
Am I allowed?
Like, no,
Yes,
what I'm
I am.
saying. No, what I'm saying, if you file bankruptcy in federal court, is someone allowed to go in to your stuff and pull that out, your federal court, and put it in these papers?
I don't know what you're talking about. I can't follow what you're saying. Did you file bankruptcy?
We did.
When?
It's been back probably 8 or 9 years.
Was this debt discharged?
It was, but it's in this right here.
Well, I can't read that. It's got
Your
a.
Honor, to go back that far. No.
The $11,000 we filed bankruptcy against, and it's in these papers.
I don't know what those papers are. I can't allow people to come up here and say, in this envelope, it's kind of like Karnak. It used to be on Johnny.
What, do you want to see it?
No, I don't really want to see it because I can't look at papers and interpret things for you. I mean, I just can't do that. Why don't you have an attorney?
Well, we've tried to get one and no one will go up against him.
Well, I can think of a
Said
lot
that
of
more
people.
often.
Yeah.
Wasn't any problem a while ago. Everybody else is up there against.
Yeah.
Well, I mean, I've tried to pay him, and like I said, he won't have it.
We've tried to pay him what?
What I owe
How
him,
much?
whatever he's
How much
asked,
did you try to pay him?
whatever he's asked for.
What do you want this woman to pay?
What?
It
Let him
don't-
tell
that
me
won't
what he
keep- Wait
wants.
a second. That won't keep the property from being
No, I
sold.
think Ms. Haddix is owed around $1,800 now. I'm not sure. We'd have to look at it. It's in the judgment.
But now the property be sold. This lady has an interest in the property, does she?
This lady has a third interest.
Third.
Her sister has a third interest.
Yeah.
Tony Alderson has a sixth interest. Stephanie Myers, Frank
So
D's
the
daughter.
property, you don't want the property sold?
No, I don't,
Well,
because
but-
I promised my mama I would keep it on her
Well,
deathbed.
here's the problem is, that's a promise that would ultimately have to be broken by someone because every piece of property ultimately gets sold. Doesn't it? Sometime it'll be sold. And if there's one person that owns any of it now that wants to sell it, it's not, you haven't broken your promise.
Yes, but I've told him I will pay her for it. I'll pay her
Yeah,
for
but
whatever she wants.
Yeah, well, then you can buy it at the sale. And see, the thing about it is, if you buy it at the sale, you get your portion of it back. In other words, let's say it brought, what would it bring, Mr. Cross, piece of property?
Oh, it's hard. It might bring 15,000, it might bring 20, I don't know.
Okay, if it brought 15,000, if you bid 15,000, you get your $5,000 worth of it if you own a third of it. Follow what I'm saying?
Yes, but I don't want it sold.
Well, you can't keep it from being sold if one of the parties wants it sold. And I will tell you what happens is it your sister that wants it sold? Is that who it is?
No, it's my
Her
niece,
niece, okay.
because he's shoving her to do
Well,
it.
yeah, well, she says that now. But that's quite frequently what people say. Well, honey, I would never do it, but that lawyer forced me to do it.
I've
It's
been
not
through that
funny.
many times. That's fine.
Do what?
I said, it's not funny.
Who's laughing? No, I don't think it's funny. It's sad, but it quite frequently happens. People say that lawyer made me do it. I've seen it happen. So I will,
I mean, I will pay whatever.
well, yeah, but you don't have a choice on jointly owned property. Mr. Cross,
Yes, Your Honor.
if this lady pays her debt, how much are you owed on it?
Oh, I think I'm over 2,500, 3,000.
Yeah, well, and this guy that owes you the money, the defendant that
I will
owes you.
pay Tony's part. We told him we would
Your Honor,
pay Tony's
if I may
part.
interject, if you knew how many times I've met with these people and how many promises.
I'm just trying to find out how much, what is he gonna bring up to sell?
I'm done. Okay, I'm done.
Okay, well, you're not done, until I tell you you're done,
Well, I
so
know.
just come back
As far as
around.
trying to work it.
See, now I'm trying to pay.
Now, here's the thing about it, it's not your debt, it's the only thing that's involved here. That's not your debt. Now, if you got a document that says you were discharged in bankruptcy from this debt, you should have filed an answer and say that this was discharged in bankruptcy. You've chosen not to get an attorney and not to file an answer. There's nothing in the file that you see you filed. Isn't that correct? You filed nothing. So I really don't have any choice but to sign the default judgment. I don't, but you can come, you'll be given plenty of notice of the sale of property and come to protect your interest in it. And Mr. Cross will probably be there and bid $2,500 or $30,000, whatever, to protect his land, right? So somebody else might be there, but I have no choice to do that, but to sign this.
Thank you, Ron.
Yeah. Thank you. Okay. DHRUVI 6 LLC.
Your Honor, Mr. Venters contacted me this morning, has filed an answer, so I will withdraw my motion for the default. That is it, his answer has been filed. I don't have any objection.
Okay, Cabinet versus Reggie Boff. Is that right? This is a child support case. What is this?
Judge, this is a divorce case that was transferred here from Rockcastle County in November of 2023.
I don't have a copy of the motion to file. Did you electronically?
Electronically filed it last Thursday.
That's the reason it didn't get in. We'll get a copy.
Judge, you can see my copy. It's a short motion.
Just tell me what it's about.
Judge, it's a motion for contempt. This is a case where there was a findings of fact, conclusions of law, and decree entered in June of 2013. So it's been more than 10 years. These parties have followed a time sharing schedule for the last 10 years, where she's primary residential custodian. He gets 3 weekends a month due to the distance between the parties. He simply has kept the child and not returned the child to start the spring school year in Clinton County. You know, the child's 15 and a half years old. He's missed the entire first week of school. He's filed nothing to get relief through the court. He's just told her that she's not bringing the child back.
Where does she live?
She lives here.
Where does Tony live?
He lives in Rockcastle County.
And does he enroll the child in Rockcastle County School?
He has, but if you read on the.
No, I'm not asking you what to read anything. I'm just asking you a simple
Yes,
question.
Dad.
Okay, I'd like you to swear your witness and just get some of it. You raise your right hand, man. Your right hand, your other right hand.
The other right hand.
Yeah, you swear the testimony that you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, I do.
Okay, you can inquire.
Ma'am, state your name for the record.
Gina Ball.
And Ms. Ball, did you go through a divorce case with Tony Ball in Rockcastle County in 2013?
Yes, I did.
And did that case go to a final hearing before the court?
Yes, I did.
And were you awarded primary residential custody of the child at that time?
Yes,
And is there only one child at issue?
yes.
What's the child's name?
Braden Ball,
And how old is Braden?
15
Turned 16 next summer.
in July.
Okay, so he's 15 and a half.
Yeah.
What is Mr. Ball's court ordered visitation that you all have followed for the last 10 and a half years?
He gets him the first, second, and third weekend of every month. He is to get him on holidays every other year. His are odd and mine is even. He got him this Christmas because it was an odd year on Christmas Day at lunchtime. He was supposed to return him one day.
Steve,
I'm sorry.
let's get down to where, what he hasn't done, not.
He has not returned the child. He was supposed to return our son on Tuesday prior to school starting.
And he has failed to do so.
Yes,
And so the child's missed a week and a half of school.
yes,
Okay. And did your court order, grant joint custody between you and Mr. Ball?
yes,
And did it also say that if there was a dispute as to a major decision to be made, that your say would go?
yes,
And have you asked that he bring the child back?
yes,
And has he refused?
yes.
And what reason has he given you?
He says that, he has, grounds of showing physical and mental abuse, I believe.
And is this the first you've ever heard of anything like this?
Yes.
Has there ever been any criminal action filed against you?
No,
What did he say that the abuse was?
he did not tell me.
And is there also an issue with is he on some kind of medication?
Yes, Braden takes allergy shots once a week, and he also on Singulair and Zyrtec. And that has not been given to him.
What's his address?
Mr. Balls,
Yes,
612 Flat Road, Berea, Kentucky.
Berea.
Yes, sir.
And are you asking the court to hold him in contempt of violation of the court's order?
Yes, sir.
And are you asking the court to order that the child be returned to you immediately?
Yes, please.
And you have concerns about the child's welfare and safety?
I do.
currently? I think that's all the questions I have.
Child want to stay up there with his dad?
I think they're in the current situation, he's, convinced him to stay.
So the child has expressed to you that.
No,
How do you know that he wants to stay?
for text.
I can't hear anything with these doors closing or anything, you know.
I apologize, Judge.
No, it's
Through
not your
text.
fault. these closures on these doors don't work like they used to. You know, they used to kind of go. Okay, who told you that he wants to stay up there beside your husband? The father, rather.
That's it.
So you hadn't had, the child, and you have not had a conversation about.
I have texted him and he has, I've got it on text showing that they. No,
What did he say to you? Either text or calling or phone about staying up there?
He said that he was gonna, that I was to, go home and remain calm and that he
Who's
needed.
this, your son?
No, he was,
I want to know what your son told you about where he wanted to go to school.
is
Either by
not,
text or phone or email or whatever.
is not.
So you haven't had a conversation with the child about you're going to Rockcastle County, Mount Vernon School now? Do you want to
The
come
only
back?
conversation
Well, let
I've-
me finish. You want to come back to Clinton County? Did you ask him that?
Yes,
What did he say?
he didn't reply.
Well, so he doesn't want to come back. Is that what you're saying? He doesn't want to come back?
I'm assuming, or he would be here.
What?
I would assume that.
How would he get here?
Well, he
He
was
can't
supposed to have been
drive.
returned.
Do what?
He was supposed to have been returned that
No, I'm
Tuesday.
talking about your son. If your son wanted to go to school here, how would he get here? He would call you to come get him, or does he have another relative that transport him?
His father would have to take them since he's.
And what if the father, and so you're assuming that the father just doesn't want to take him? So the son is undecided about where he wants to go to school?
I'm unaware of that. I can't answer something that I have not spoke with him about.
Have you spoken to the child at all since he didn't?
Through
come back? Let
text.
me finish my question. Is that okay if I finish my
Yes, sir.
sentence? Have you spoken to the child at all about anything since he didn't return on the date he was supposed to?
It has been very brief and very little, sir.
The answer to that would be yes.
Yes,
Okay. Now, this is how you and I are going to get through this. I ask a question, you respond directly to it, okay? So you have spoken to him. And what did he say to you? He didn't mention at all that he wasn't back or he wasn't coming back or wanted to stay up there. He didn't mention anything about it. The little boy.
No, sir.
Yeah. Did you ask him?
Yes.
And he just was silent, correct?
His reply was, Mom, I love you most of the time, or sending a heart emoji or something to that, or I'll see you soon.
You have anything else?
No, Your Honor, not as far as questioning, no. No, I
Okay,
would
now
just
you want to
simply
make an argument?
Yeah, Judge, I mean, as Your Honor is well aware, I mean, there's ways to go about modifying time shared custody, and the way to go about it's not unilateral defiance of.
Well, I'm thinking that you're entitled to a contempt order. I don't necessarily think it's the best thing to do, but you're entitled to it. There's something else we're not hearing here. I cannot believe that this lady has not had a conversation with that child, or the child won't respond. I'm not saying you're not telling the truth. I'm just saying it's hard for me to believe that the child, if he wanted to come back, wouldn't have said something that he wanted to come back, or I'm happy here. Then he said nothing. I'm not saying that didn't happen, okay? It's very unusual that it didn't happen. When you contact him and say, where are you, Junior? Why aren't you here? And he doesn't say anything about I love you. So I don't know if he did, but we will find out, I would say, when you get an order and have him to immediately return the child. You give him till in 24 hours from the day he served with this order to get the child back here. Or he should be found in contempt of court, in order to spend 60 days in jail.
Judge, I'll draft an order and tender it.
Okay. Now, if I find out you're not being completely candid with me, it's not gonna be good when I make that ultimate decision. There'll have to be other hearings about this at some juncture, because there's some problem here. I don't know what it is. It's his perception of how you're treating the child, which might be all wrong. Okay? Or it's the child's perception of how he's being treated anyway. I want to talk to you about it. That's the reason it's more complicated. You're entitled to this order. I don't necessarily think it's the best way to go. If you send him a warning letter to bring the child back, or give him any other notice other than this motion?
No, Judge, she came to meet with me Thursday, and that was the deadline to file.
Well, you know, you might very well get the order to me today. And then I would attempt to make some contact with him and tell him to have the kid back down here tomorrow and have him in school.
And I can definitely have her relay that text message.
Well, I don't
whatever
really want her to have to relay that to her child. I don't want her to be the one that tells the child he has to come home.
No, I meant to.
I know, but that's the way it will be perceived by the father. Your mother called up here and said, I have to bring him. He needs to get a court order from me. And hopefully it won't harm whatever kind of problem you've got with your child. And you got some kind of problem with the child. There's some kind of problem there. I don't know what it is. I hadn't heard it yet, but it's there. Okay, thank you very much.
Thank you, Judge.
Okay, what else do we have on the docket?
She went to the bathroom.
Yeah, the bathroom, like, went to the bathroom.
Oh, yes, my client stepped out, Your Honor.
She gonna step back in?
Oh, sorry. She's returned.
Okay, have her come around. I love that. Okay, now this is one that we were gonna send down to the Domestic Relations Commissioner.
That was my understanding, Your Honor.
Okay, but let me, before we go down there, see if there's some accord that can be reached. It's not been a day of great accords. Who's got the problem here?
Judge, it's our motion. He hasn't seen his little boy in a year. And he's filed a motion for relief for because
What's the problem?
Your Honor, the
I'm
problem.
not gonna take any proof. The commissioner will take the proof. Can't work it out.
I understand. What we would say the issue is there was an incident which led to Mr. McWhorter not seeing the child, which was him shooting at my client's belongings, including a Bible.
You doing what?
Shooting my client's belongings, including her Bible, urinating on her possessions, including a childhood heirloom, presumably that would have been passed to their child, and committing domestic violence. So that is what has led.
DVO on him?
Yes, she has a DVO.
Still in
against him.
place?
It is, Your Honor.
What does it call for towards visitation?
It did not address custody or visitation at all, and Mr. Garman had filed this action. We filed our response back in August. I had expected him to file some kind of temporary motion, but he's done that now. So my client still has concerns that Mr. McWhorter has not addressed his anger problems and has some concerns with his mental state, that he would shoot someone's Bible, urinate on all of their belongings.
Well, I have
So-
a lot of concerns about shooting the Bible. You know, most of them would be long-term sort of thing. I'm not saying he did shoot the Bible. So. Well, it sounds like y'all need to go take some testimony. Have you talked to the commissioner?
I have, Your Honor. He
When
indicated,
can he set a hearing?
that's what he was gonna have us address once Mr. Garman was finished over here.
Okay, well, y'all get on down.
Thank you,
Thank
Judge.
you, Your Honor.
Orton versus Orton. What do we have here?
Judge, we were here previously and we had entered an order where he would receive visitation with the three children, 1 hour per week, supervised by her aunt. And in the order, we had listed that it would be reviewed today.
Yeah, see that.
We are asking that there be no additional visits at this time. And the aunt is willing to continue for another period of time to supervise.
What do you mean, no additional visit?
No additional visits.
Discontinue, that the visitation as it's now in place continue?
Yes, that it continue, but
So
no
when you say-
additional.
Well, when you say that there be no visitation, you could take that as you don't want him to have any visitation. But so you want the temporary visitation schedule to continue for how long?
To stay in place, at least maybe 3 or 4 months. I know Mr. Orton is in drug court and we don't know how long he's gonna be in drug court or the status of
Okay,
that.
how the visitation's going?
You want to hear from my client or
Yeah,
myself?
I'd like to swear to raise your right hand, please. Swear the testimony about to give us the truth, whole truth, and nothing but the truth. You get on her side over here. You get on her side. You get in the middle. State your name, please.
Hey there, Danielle Orton.
Okay, go ahead.
Visits are going well, I think. He missed this week's visit, which he said he was sick, so that was fine. I agree with that. The kids don't need to be around that. They're supposed to do it tonight, I think. He missed the first one, but I think it was like communication error there. But other than that, it's going good, but I have concerns with some stuff that he's posting on social media.
Like what? Just tell me. Just tell me.
He gave the kids a phone the last time he was here. The kids have the phone. I have to make them call him, but yet he wants to accuse me of not letting them call him. I'm good with whatever they want to do. He posted something about if people don't quit pushing him, then he's gonna get that IDGAF mindset back. And people's
Gonna
not
get
gonna
what?
like the, it's, I don't give a mindset, and he doesn't care pretty much who it makes mad. Yeah, people wouldn't like the outcome.
Post that on Facebook or where?
Yes, it's on Facebook.
You have a copy of it?
I do.
Sure.
That was just 2 days ago. 2 to 3 days ago.
I know, fine.
Yeah, great. I just want to give you.
It had nothing to.
Wait a second. Okay, go ahead. Introduce that as exhibit number 1. for the petitioner. Go ahead.
The kids enjoy seeing them, I think, but they don't, I have to make them go.
How old are they now?
7, 9, and 12.
Okay, anything else?
Does your oldest daughter create more of a problem in making her go?
She fusses about it, but I know she loves them.
She's 12.
She's good.
I'd say she'd be fussing about everything at 12.
She's got her days.
I just have one other question. Has your aunt reported any other observations in the most recent visit about his interaction or inability to
said-
interact?
I don't know if it's this past time or the time before, but said he was on his phone quite a bit, but other than that, there's not been nothing bad. Said,
Yeah, do you have any questions you'd ask her? I'm gonna let you, I'm gonna let you testify yourself. Wait. But you can ask her questions now. You can't testify. Put her back in the center here. Put her back there. Okay. You can ask her questions now, and then later you'll get to testify. So I don't want you testifying now. Is there any question that you want to ask her now?
Yes.
Okay, go ahead.
Last night, when we had our phone call, when they called, Tessa, the oldest from the 12-year-old.
You're testifying. Ask her a question.
Did she not say she would like to see me more on the phone?
I don't listen to your conversations.
Okay.
They go in the bedroom and I'll go to.
Do you have any other questions?
Yes. You say you don't listen to our conversations, but you've actually chimed in about the stuff with the Christmas presents and
When you,
stuff. When I was actually.
Wait. I told you to ask her a question. You'll get to testify in a minute, okay? You can ask her a question. Have you intervened in phone calls we've had? Have you talked? You can ask her that question. That's a question, but you can't just take off like this. I'm not gonna have a fussing contest here.
he asked the kids what size they wore. They didn't know. I told them the sizes, they told him.
Okay, now you have any other questions?
No, sir.
But okay, now do you have any redirect?
Just one question. Do you feel that the current visitation should continue as it is now for a period of time, as long as your aunt will supervise it?
Okay, here's the thing about it. It's important to have testimony on how somebody feels. She probably feels a lot of things. He probably feels things, but I don't rule on what people feel. If she has any reason why the visitation ought to stay the way it is, or whether it should expand. Now, I call it back up for review. There's no motion here to expand it. We're just reviewing it right now. He needs, as always, needed to lawyer up, which he's never done, if he wants to expand his visitation, okay? So if you want to ask her any other questions, it might give me any reason why I shouldn't expand it or why it should be limited, okay?
Do you feel that it's in the children's best interest that there be more visitation?
Okay, I know that what she feels about that. Okay, thank you. Okay, now you can come over here. You come over there, you raise your right hand. Swear the testimony you're about to give us the truth, the whole truth, and nothing but the truth.
Yes, sir.
Go ahead.
Your Honor, I am in drug court. I will be in phase 4, February the 4th or 5th. I'm not exactly sure. No failed drug tests, no failed meetings, always going to my Donna. I've not done anything wrong. I show up, I've tested positive for strep, so I'm just so fair warned. Just like our aunt also missed a meeting and said, hey, can we do it on Thursday? I was over here coughing a while ago. I'm sick.
Well, I'm not impressed by the couple of times you've done this to me. Don't be coughing.
I know, I'm sorry. The thing on Facebook, Barry Cross is already addressed. It had nothing to do with anything else
Well, it's
other
not
than me
very
getting.
smart to put something like that on.
I was getting threatened for my life.
Well, here's the thing about it is, if you're getting threatened for your life, you ought to go to the law enforcement or somebody else. Because anybody that has any kind of problems, you could take a look at that and use it against you later if something happened to it.
Barry Cross, like I said, I've addressed it. I can't take it to the law here at being family. There's a lot
Yeah,
to this.
you can take it to anybody. You can make a complaint to anybody, whether they're family or whatever. You go to the sheriff's department or you go to the county attorney and file a complaint. Go to the county attorney and file a complaint. So,
Your Honor, last night when I was even on the phone call with him, and I've asked him several times, I'm not asking for overnights, but I would like to be able to. I'm not going to keep them. I love my kids dearly.
okay, well, here's the problem. I'm gonna allow you to at least keep what you have now. This is not gonna be limited, but you need to get somebody to file a motion for you. Okay,
Yes.
it appears to me that you have made progress in this drug court thing. That's what it's about. But you're still a little jacked up, and you get jacked up about your family and that sort of thing, but that will jack people up,
Yes.
okay? So that's the reason that people cannot represent themselves, because it's like asking somebody what minor surgery is. Minor surgery on somebody else,
Yes, sir.
somebody else's kid. Visitation, with your visitation, and the fact that she willingly admits that the children still enjoy being with you. You know how much blessing that is for you, that after everything that's happened, that these children still want to be with you. You know why? Because children naturally love their parents even when they don't deserve to be loved. So what you need to do, rather than try to come and argue this yourself, is get a lawyer and let the lawyer work with Miss White and the mother to see if y'all can gradually expand these visitations back. And when you get finished with drug court, keep your job, things turn around, you chill a little bit and everything, that y'all can live your separate lives and co-parent these children. So I'm not gonna give you any more visitation today because I don't have a motion from you, but I'm not gonna take any of it away from you, okay?
Can I say one other thing
If
about
you
this?
want to, you're
With the
probably
article,
better off
they,
than not.
well, I mean, with the article, like they turned in for evidence a while ago.
Yeah.
I have blocked her, my family, her whole family. And in my opinion, they need to quit stalking me. I get comments, I get things.
What do you mean
all the-
stalking? What do you
Well,
mean stalking?
I have her blocked on every social media, Snapchat,
Well, here's the
everything.
thing about it.
Yet they keep,
Somebody sees something like that, I'd want to know if the father or mother of my child was putting something up there, especially if I was concerned about him anyway. So maybe a relative or somebody sees that and sends it over to him. It would concern me on whether my daughters or children were going to come over to see you if you're putting stuff up there like that. So I better not see more. Just keep it to yourself, man.
one more thing.
Yeah,
It's just,
well, you're not helping yourself. but
no,
keep
this
on
is
going.
about our visitation, Your Honor. I know I'm not supposed to be within 1,000 foot of her. She's coming in early to our visitation and sitting in the parking lot, McDonald's, Majors. I don't want anything to be used against me. Can her aunt please inform her when her
Well,
visitation's
I
over?
want to tell you, if you're at the McDonald's and she pulls up out the parking lot, and I'm not gonna say anything about that, it's okay.
I just don't want charges against me. Your
Well,
Honor.
have you been pulled up McConnell? It's okay.
Like, I don't do anything. I sit there and I make it.
Okay, well, that's okay. Just don't worry about that.
Okay,
portion.
I just don't want to get
Well,
myself.
that's one thing that you don't have to worry about.
All right, thank you, Your
Okay.
Honor.
Okay, now you can go ahead and leave.
Okay.
And we'll you get a short order that the visitation as is will continue for 3 months, 3 months, okay? Okay, thank y'all very much.
You want me to put a review date or just say and it may be brought back?
The rule, let's come back on April the 11th. See if we top it over, okay? Hey, let's go off the record.
I want to look and make sure